Pardon to mention, my lord. My lord, one item is there in my lordship's weekly list, my lord. Item number 34 for hearing. It was previously also in the list. Now is also on the list. Out of my lord 10 years sentence, the petitioner already undergone 10 years. Only because of the my lord fine amount, he is inside custody, my lord. May I pray to be taken up any day, my lord.
All right, we'll see that. Mark also. Yes, next.
My lordship, the petitioner is in the custody since 2019. And once I have filed a memo, mentioned memo, and subsequently it was allowed by this honorable court. But still yet it is not in list.
Okay, give it.
And 4 other tied up matters, my
I
lordship.
may be pardon to mention, my lord. Today the weekly list item 222. Juvenile matter only for orders or only for bail, your lordship, not for hearing.
Which one?
222, item number 222.
तेरा
Criminal division matter.
अच्छा
Only for bail.
तेरा yes
Your lordship kindly taken up.
tomorrow yes well. It will come tomorrow in the supplementary list.
Pardon, my lords. Criminal bill 318 of 2023. Earlier it is admitted and records was called for. In the meantime, it is received for bail. Another application, another bail application 4590 of 2023. My lords had it before vacation and CD was called for. Now the assigned matter is before my lord Justice Gauri Shankar Satpathy, my lord. But only because my lord had it, therefore it is not being listed in spite of several memos they filed there, my lord.
Give it, will see that.
Pardon to me, mention my lord, serial number 694 of 2018, my lord. Petitioner custody in 5 years out of 10 years, bail matter, man. Another matter, man, hearing matter, 8-year custody out of 10 years, man. Page 10, item 45, my lord. Vigilance case, hearing matter, my lord.
Wait. Please. Yes.
And it taken up, my lord, today or any other day, man?
Serially, Mr. Counsel, yes.
I have submitted the written notes of submission.
My lord, beg your pardon to make a mention, your lords.
Here. Why have you kept these books here? Why have you kept these books here? Come to this side.
One 56 item in the weekly list, your lordship. I have filed, it is listed for hearing today. I have filed a bail application, interim bail application, your lordship. So can it be taken in the bail list, your lordship?
All right. Add to the bail list on Monday. Monday it will come in the, yes.
Supplemental list item number 1.
On the last occasion, your lordship directed the State Council to take instruction regarding the property.
No, your bail application was allowed since 9/11/2021.
Yes, my lord.
So you have been released from custody or not?
Yes, my lord. I filed for modification that your lordship directed to make deposit in installment. The petitioner could not make the deposit, my lord.
Yes.
Some amount he deposited, my lord, 8,50,000, and subsequently after filing of the IA, your lordship directed to make deposit of rupees 3 lakhs. I have already deposited 3 lakhs, my lord. And for the remaining amount, I have I filed the affidavit that properties that should for the remaining amount, the petitioner will furnish property security. And that was your lordship directed the State Council to take instruction in the matter regarding the valuation of the property.
Whose property is this?
Third party property. As per the order dated 28/3/23 in IA number
2/5/2023 is the last order.
Yes,
2/5/2023.
yes, ma'am.
On that day, it has been mentioned that Mr. Das filed the details of the property surety by way of an affidavit with documents as per the order dated 28/3/2023. And copy was handed over to Mr. Patro, who wants to take instruction regarding the genuineness of the sureties and authenticity of the documents and also the valuation of the property. So what instruction you have taken, Mr. Patro? Yes?
So to the last amount, my lord, he has to pay the last balance amount 26 lakhs amount.
Yes.
For that, he has furnished his document, my lord.
Right.
I obtained instruction from concerned Tahsildar, my lord, passing on the original.
Three things I have stated you, Mr. Patro. One is the genuineness of the sureties. Number two is the authenticity of the documents filed. Number three is the valuation of the property.
Three things are there.
So what is your inference? Where have you stated that the petitioner had arranged the property surety for the balance amount of rupees of one Ghanno Naik, son of so and so, has agreed to give the following property as surety for bail to the petitioner. The following are the details of so and so. In this regard, the matter was verified from the office of Tahsildar Adgad and came to surface the owner of the land, Ghanno Naik, is no more. He died on so and so. The son of Ghanno Naik so and so submitted credentials and letter citing that his father is no more and he does not know any Sima Naik, who is supposed to have made the dealing with the father for keeping the aforementioned verification so and so. It is ascertained, and in the meantime said land has been taken by Visa still. How did you furnish this land? Neither that man in whose name it stands, he has expired. The property has been taken by Visa. What is that? Visa Steel through land acquisition for his factory. How that property can be utilized? Give a copy. Let him go through it.
Yes, sir.
The Learned Counsel for the Mr. J.P. Patra, Learned Counsel, appearing for the state of Orissa in OPID Act matter, submitted the written instruction received from Deputy Superintendent of Police EOW and IO of the case as per the order dated 2/5/2023. Let a copy of the same be handed over to the Land Council for the petitioner in order to enable him to take instruction in the matter.
I have only the instruction. Annexure guda sitra umar extra.
ଏଟାକୁ ଦେଇ ଦିଅନ୍ତୁ ତାଙ୍କୁ
କରିକି ତାଙ୍କୁ ଦେବି ଆଜ୍ଞା annexure ଗୁଡ଼ା
when do you want this property? Neither the person whose name that property is there, that property has already been taken away by one private company. So
I will take instruction.
right, take instruction. So it will come 2 weeks after. Give a date. Yes.
Weekly list item number 1.
Yes.
Appellant to another person has the trial in the trial.
Please use the mic properly. So where is Mr. Who is for the other side?
Sarthak Naik.
Sarthak Naik.
I may be pardoned, Your Lordship.
Yeah.
Your Lordship, on the instructions of the Counsel for Special Public Prosecutor for CBI, Your Lordship.
Yes.
Your Lordship, this matter may be passed over to 2 p.m. Your Lordship. He's there.
Lordships.
Mr. Naik, it's a pattern matter. Why are you seeking time?
May I please, Your Lordships?
Are you not able to hear me? This is a pattern matter and it is item number 1.
Yes, Your Lordship. Your Lordship, the
Why are
matter
you
was
asking for time?
Your Lordships, I'm not asking for time. Your Lordship, this matter is already over. Arguments were over in this matter.
Yeah.
If Your Lordships will exactly remember, Your Lordships, both the sides had already argued the matter. It was only listed for Your Lordships for some judgments to be provided by the counsel for the petitioners.
You know, what is the last order passed?
Because it was extensively argued, Your Lordships.
Just a minute.
I am only seeking for a passover at 2 p.m. Your Lordship, because there is a part third matter to address Your Lordships. Lordship, that is a space.
What is the date when the matter was last listed? All right, we'll take up this matter at 2 o'clock. Yes.
Item 2.
What is this matter, Mr. Bharana?
Item 2, 1 Passover.
On whose behalf you are mentioning?
Weekly item 2.
On whose behalf you are mentioning?
Mr. Chittaranjan Patnaik.
I am here.
Okay.
How many appellants are there?
No, only one.
Then why he is?
Because he was appearing. That's why.
Oh. Mr. Das, where is your power in this case?
The last occasion I had filed before this honorable court.
देखले अच्छी है cause list क्या है लोनी देखिए वकालत नो You have filed a wakalatnama or memo of appearance?
Accept memo of appearance. वकालतनामा আছে।
Person, let me see that order. When that order was passed? Show me that order. You asked to supply the Xerox copies of all the documents exhibited.
Had been supplied by the office.
Find out the consent memo.
Yes, my lord. It is there.
ସେଇଟା
Where is the consent of the previous council? Please verify it. That's why he's coming and making a mention.
Last occasion, your lordship had it part.
It's all right, but since he is opposing, so
That's all.
he's seeking time. At least he should have mentioned, I have no objection. So
Right.
that's the formality. I have nothing to say. But when she is raising objection, that's why the
ସେଇଟା ଦିଅନ୍ତୁ ସାର୍ ଦେଖିଦେବେ ସେଟା ସେ ଭି ନାମରେ ଥିବ ସେଇଟା ଦିଅନ୍ତୁ ଫାଇଲଟା ଦିଅନ୍ତୁ ସାର୍ ଦେଖିଦେବେ
The consent memo is there, but there is no consent from the
right. That is exactly Mr. Das authorized. So let Mr. Patnaik come and let him endorse that so that I can take it off. I have nothing to. What is the offense here?
7 and 13(2) for the PC Act.
This decoy overhearing witness supported the prosecution case.
Overhearing witness has not supported because he has said that I cannot identify who the person was trapped.
You are the associate of C.R. Patnaik. Ask him to come so that let him either argue or give the consent to Mr. Das, because you interfered and the senior counsel is standing. Ask him to come.
Overhearing witness has denied his knowledge about the identity of the person who was trapped. He said that I cannot identify the person who was trapped. I cannot say the accused standing.
What are your points, Mr. Das, in this case?
Briefly, the allegation of the prosecution is that the father of the complainant was a primary school teacher.
Yes.
Died on 29/3/2003. The bill for unutilized leave was submitted to the Palhada Sub-Treasury, and that was processed by the dealing clerk who was the accused. So, later, the gratuity and provisional pension bill was also submitted to the. At that time, he demanded ₹1,500
for processing the gratuity area.
Gratuity and leave salary.
Okay.
Pension. He demanded ₹1,500. It is alleged that the complainant paid ₹400 and the balance.
No, when the demand stated to have been made first time.
Demand stated to have been made on 1/11/2003. 3/11, sorry. 3/11/2003.
3/11/2003. That was made for the first time.
Yes.
At which place? At which place it was made?
In the office.
in the office of the appellant.
Yes.
Okay. That is the sub-treasury office.
Sub-treasury office.
So what was the amount demanded?
1,500. Out of 1,500, it is alleged that he had paid 400 and balance 1,100.
400 when he paid?
That is on 3.
On that day?
4.
Yes, Mr. Patnaik.
On 4.
Mention it that I have no objection. That is the problem. Your associate sought for an passover when the counsel is there. He is ready to argue the matter. So you should have mentioned in the that I have no objection. That you have not done. That's why. Yes, Mr. Now you proceed. So Mr. Das, on 3/11/2003, the demand was made, and that too of amount rupees 1,500 as bribe in the sub-treasury office Palhada by the appellant to the complainant, right? And for processing the gratuity and leave salary arrears bill. Okay.
So what he has stated, that is the prosecution case in the FIR. But the evidence he has not stated.
No, let us go step by step. Let me first tell you about the prosecution case in the as per the FIR. So on 3/11/2003, any amount was paid or
no? The amount was paid.
No, you said
411. 411.
That 400 rupees you paid. All right, just a minute. That amount was paid at what place?
In the office.
In the office. So the balance remained rupees 1,100.
100. It was decided to be paid on 14/11/2003.
At the in that very office.
Yes.
Okay. So then when the FIR was lodged?
FIR was lodged on 13/11/2003.
And this preparation was made on 14th.
14th. Preparation, detection. I have submitted a synopsis there. Your lordship has mentioned.
No, just this. Are you disputing the acceptance and recovery?
Yes.
You are also disputing. So where from that money was recovered?
The money,
according to the official witnesses, if you are disputing that, then where from that was recovered?
No, in my pocket.
So
in my pocket, because
the explanation is something.
No. The evidence is that the complainant put the money inside my pocket.
Mr. Das, I am telling you that
recovery
yes.
From my pocket.
Recovery from your pocket. Okay. So recovery admitted. Then question is acceptance.
Demand and acceptance.
Demand and acceptance is dispute. Okay. Well, let me first come to what is your plea. We'll go to the prosecution case. What you have stated, what plea have you taken? That how this money came to your pocket.
My plea in the accused statement is that.
Yeah. Let us see the accused statement.
At page 67.
Accused statement.
Last question.
Just a minute.
May I place my?
Yeah, trial court record. Just
paperbook.
Paperbook.
Page 67 paperbook.
$67.
My lord.
Okay. No. Let us go one by one. First question, you have admitted that so-and-so stated that you are serving as junior clerk in the office of the sub-treasury office. Okay. Then you are telling about Micha, Jani Nahi. Okay, in this way. Okay, let us proceed to the last question.
No, question number 15 is irrelevant.
15, okay. So, 15.
I have denied. That the specific question was the 1100 was demanded and you accepted
he
that.
replies so-and-so, a certificate and gave it to you, accept. Okay, you have denied. Then, hand wash you have admitted.
Mila.
Shirt pocket wash you have admitted. Cotton wash portion of your office almirah. So, Mr. Das, it was not kept in your pocket. You kept it perhaps in the almirah.
No, that is the subsequently it was introduced, but it has not been stated before the.
No, that's why I'm telling you that where this money, tainted money was recovered, whether from your shirt pocket or from the almirah. Then the why the cotton wash of that office almirah was taken?
It is alleged that I kept the money after receiving the money in my pocket. I kept the inside the almirah.
Then how from your shirt pocket it was recovered?
That is the evidence of the prosecution witnesses.
All right,
that part was subsequently introduced. That was not.
All right, come to the last question. That is page 67.
67. ए घटना बहुत दिन पूर्वरु महेंद्र साहू आम ऑफिस को बारंबार आसुथला एवं लोक मानक काम करो बोली धमक चमक दउथला से कहउथला से नेता एवं लोक काम जोर जबरदस्ती कराइबो मु घटना पूर्वरु कहितली एमिति कोन धमकाउछु से मते कहितला देखिदेबी घटना दिन हठात मो ऑफिस रूम को आसिला एवं मु काम करता अवस्था रे आसी मो संगे हाथ मिलेला किछि टंका गुंजी दे मो सार्ट पॉकेट रे चली गला मु ताकू डाकू डाकू सुनला नाही विजिलेंस वाला आसी पॉकेट टंका बाहर करी कहले एवं गणिया को कहले मु बाहर कली गणिली ए केस मो विरुद्ध रे मिथ्या तथ्य देई महेंद्र साहू कराइछि मु ताकू लांच मागी नाही कि ग्रहण करी नाही मु तार बापा फाइल 2 दिन पूर्व अकाउंटेंट पाखु पठाई देथिली ताहा मो पाखर पेंडिंग नथिला.
Okay, that means you are first taking a plea that no work of PW1 was pending with you. That is one of your case. The other thing that it is a forcible thrusting of money into the pocket.
And there was a strong animosity because of previous incidents.
So, it is also the prosecution case that this money, tainted money, was recovered from your pocket. Anybody has stated about keeping that in that almirah?
So that one stage it has been stated. PW1, the complaint has stated, and paragraph 7, being asked by the vigilance personnel, the accused went and brought out the tainted money from the said almirah.
No. In paragraph 6 also he has stated.
Accused accepted the same.
Kept the money in the left side pocket of his wearing shirt. Then he took the money and kept it below some files in the office steel almirah. At that time, what is then the state evidence of this vigilance officials about the recovery of the money?
That is.
Who are those officials?
My lord, TLO is PW4.
PW4 is the TLO. Okay. Let us see where from he recovered. Please come to paragraph 3, page 80.
My lord. We left for Pallada Sub-Treasury, reached there at 11:40 a.m. The complainant and accompanying witness proceeded to Sub-Treasury office Pallada, and other members waited near the Sub-Treasury office. At 11:55 a.m., accompanying witness Rabindra Kumar Behra gave clearance signal. We rushed to the spot. The accompanying witness stated that as per demand of the accused, the complainant paid the money and the accused accepted the same. We rushed to the accused, gave our identity and ascertained the identity of the accused from his mouth, and challenged him about the acceptance of money. The accused became nervous and pale. Then he agreed to have received 1100 from the complainant for passing the bills. The accused stated that initially he kept the tendered money in his chest pocket, and subsequently he kept the same in his office almirah. Then left hand wash of the accused was taken, and the color of the hand wash became pink when it came in contact with the sodium carbonate solution. In the same manner, the right hand wash was also taken in a separate glass, which also turned to pink. Both hand washes were sealed in separate bottles. The accused pointed out the almirah in which he had kept the tendered money. Master witness G.C. Ratha opened the almirah and found the tendered money were kept under the bunch of files. He tallied the serial numbers of GC notes and found that the numbers and denomination tallied with the denomination and numbers noted down by him earlier. Afterward, I also tallied and found correct. I seized the tendered money of rupees 1100 in presence of the witness and prepared a seizure list. I seized the document in which the master witness had noted down the numbers and denomination of the GC notes during preparation.
So that means the GC notes were first kept in the pocket. That is the prosecution case. Then it was kept in that almirah, from where it was recovered. Okay, so if recovery is not disputed, maybe from your shirt or maybe from your almirah, then this plea which you have taken, your accused statement, let us come to once again to that accused statement plea.
67, page 67. ଘଟଣା ଦିନ ହଠାତ୍ ମୋ ଅଫିସ ରୁମକୁ ଆସିଲା ଏବଂ ମୁଁ କାମ କରୁଥିବା ଅବସ୍ଥାରେ ଆସିକି ମୋ ସାଙ୍ଗରେ ହାତ ମିଳାଇଲା ଏବଂ କିଛି ଟଙ୍କା ଗେଞ୍ଜି ଦେଇ ମୋ ସାର୍ଟ ପକେଟରେ ଚାଲିଗଲା। ମୁଁ ତାକୁ ଡାକୁ ଡାକୁ ଶୁଣିଲା ନାହିଁ। ଭିଜିଲାନ୍ସ ବାଲା ଆସି ମୋ ପକେଟରୁ ଟଙ୍କା ବାହାର କରି କହିଲେ ଏବଂ ଗଣିବାକୁ କହିଲେ।
First of all, tell me whether this particular plea which you have taken in your 313 statement, whether it has been suggested to the complainant.
Yes.
Let us see that. Come to the suggestion part.
So at paragraph, your lordship may come to paragraph 13 at page 71. May I place my lord?
Yes, yes.
On the date of the occurrence, the accused told me that our work had already been done. I had given the money in question in the shirt pocket of the accused, but I do not remember the exact pocket in which I kept the said money. Since my childhood, I am suffering from sickle cell disease, and due to this disease, I feel sickness.
I had given the money in question.
My lord, I had given the money in question in the shirt pocket of the accused.
No, in the shirt pocket, no. See, then perhaps he said something is omitted there.
No, that is illegible, but I have found out from the record that it is the shirt, the portion which has been omitted in.
He said like this.
In the shirt.
In the chief examination. I brought out the tendered money of rupees 1000, paragraph 6. 1000 from my left side pocket, chest pocket,
and
gave the same to the accused. Accused accepted the same, kept the said money in the left side pocket of the wearing shirt. Then he took the said money, kept it below some files in the office telegram. So, okay, now you will go to that particular paragraph where you are placing.
13.
13.
On the date of occurrence, the accused told me that our work had already been done. I had given the money in
paper.
question.
Just a minute. Okay, please come to paragraph 13. Yours.
On the date of occurrence, the accused told me that our work had already been done. I had given the money in question in the side pocket of the accused, but I do not remember the exact pocket in which I kept the said money.
I kept the money or he kept the money?
No, I kept it. You'll also
No.
see the original accused statement. In the paperwork, some part has been omitted.
Demonstration. What is the original record? No, this doesn't make any sense because it is completely contrary to the chief examination.
Yes, yes.
And it's a vital thing because
not only here, subsequently also he has admitted the same thing.
Where?
In the subsequent paragraph. Paragraph 17, your lordship, may kindly see. I cannot say the date when I had earlier given 400 to the accused and the names of the person who were present at the time. I was present at the office veranda at the time the money was recovered from the side pocket of the accused.
Even in the paragraph number 14 also.
Yes.
Whether you had given the said money in the shape of.
Yes, that was a question by the
said GC notes were recovered from the pocket of the accused.
Accused,
That is.
It's a question answer form. It has been recorded. The specific question was whether money was
Okay, so there is some kind of discrepancy as to from which
Place, where
place, either it was from the side pocket or from that almirah it was recovered as per the evidence of PW1. But the official witness stated that it was recovered from
official TLO.
TLO, that is PW4,
My lord.
that it was recovered from that almirah. And the cotton was of that portion of the almirah was also taken, and it was also found to have yes, right.
Color, pink color.
Now let us come to the demand part. The evidence of demand is stated about balance amount of rupees 1,100 to be paid as per your demand.
I am placing from paragraph 3 of the PW1.
Yes.
Then the bill for rupees 90,800 in the name of my mother was sent from the block office Palhada to the sub treasury for drawal of the death gratuity and provisional pension, area pension of my father. I again made the accused at his office. He told me unless I give him rupees 1,500 to him, the bill will not be passed. I paid him rupees 400 with assurance that I will further pay 1,100.
Okay, just this part, this 400 rupees payment on the very day, on what date it is not mentioned, but any corroboration to that effect?
That he has again contradicted it. Paragraph 17. I cannot say the date when I had earlier given rupees 400 to the accused and the names of the person.
No, that he said a date cannot I give, but say that 400 rupees was paid. No, I just want to know that whether there is any corroboration to this from the other witness.
Because overhearing witness has.
No, overhearing witness comes later on. About this 400 which was paid on
Earlier.
Earlier. To that effect also there is no corroboration. Okay, then this preparation leave it. Now come to the paragraph number 6. Yeah.
Then we all members of the trap team went to Palhada in a vigilance jeep. Then I went inside the office of sub-secretary office Palhada, being followed by the witness Ravindra Kumar Behera. Then I met the accused. He asked me if I had brought the money. I answered in affirmative. Then I brought out the tented money of rupees 1,100 from my left side chest pocket and gave the same to the accused. The accused accepted the same and kept the said money in the left side pocket of his wearing shirt. Then he took the said money and kept it below some file in the office steel almirah. At that time, the vigilance personnel trapped the accused and caught hold of the accused. Being asked by the vigilance personnel, the accused went and brought out the tented money from the said almirah. The hand wash and the pocket wash was of the accused was taken by the chemical solution, resulting change of color of the solution to pink. Since I was feeling uneasy, I was allowed to sit at the spot and the vigilance personnel prepared their papers. Exhibit 3 is the detection report prepared at the spot. Exhibit 3 by 1 is my signature. Cross-examination part.
No, Mr. Das, let us take your plea into account. If it is your case that he thrust it in your pocket, then how your hand was turned pink?
I was just calling him that. I just wanted to call him. Why? Then my plea is your lordship kindly see. ଯଦି ମୋ ସାର୍ଟ ପକେଟ ଚାଲିଗଲା ମୁଁ ତାକୁ ଡାକୁ ଶୁଣିଲେ ନାହିଁ ଯେ ପକେଟରେ ଟଙ୍କା ବାହାର କରି କହିଲେ ଏବଂ ଗଣିବାକୁ କହିଲେ.
No.
The hand wash was taken after it was recovered by me from my shirt pocket.
That is You see, please read it once again.
My lord.
Because if you are taking a defense plea, the proving of the plea, that standard may not be there, that beyond all reasonable doubt. But preponderance of probability, if that is there, then that is to be also seen. And if surrounding circumstances assist your plea, that can also be taken into account. So what you have stated that
ମୁଁ କାମ କରୁଥିବା ଅବସ୍ଥାରେ ଆସି ମୋ ସାଙ୍ଗରେ ହାତ ମିଳାଇଲା, କିଛି ଟଙ୍କା ଗେଞ୍ଜି ଦେଇ ମୋ ସାର୍ଟ ପକେଟରେ ଚାଲିଗଲା, ମୁଁ ତାକୁ ଡାକୁ ଡାକୁ ଶୁଣିଲା ନାହିଁ, ଭିଜିଲାନ୍ସ ବାଲା ଆସି ପକେଟରୁ ଟଙ୍କା ବାହାର କରି କହିଲେ ଏବଂ ଗଣିବାକୁ କହିଲେ, ମୁଁ ବାହାର କରି ଗଣିଲି এই କେସ୍।
Okay, so this is only except taking this plea by, there is no supporting material to that. That is only in your accused statement.
Yes. No, that is one. There is one evidence that the hand wash has taken after recovery. That is there. Hand wash has been taken after recovery of the money. Well, and in this case, my submission is twofold, my lord.
Yeah.
There is direct evidence and the circumstantial evidence. Direct evidence, that is very shaky because there is no corroboration from the independent witness. That is the overhearing witness has not supported.
So who is overhearing?
PW 3.
Yes.
PW 3, you'll also may kindly see the evidence at page 74.
Wait, just a minute.
74 of the paperwork, my lord.
Yes. When the last order was passed, it was hard in part, na two order. देखिए, the order of hard.
At page 74, may I place, my lord?
On
14/11/2003, I was junior clerk in the collectorate Onugul. On that day, as per the direction of the ADM Onugul, I had attended the office of the DSP Vigilance Onugul. Girish Chandra Ratha, Nijarat officer of the collector.
No, Mr. List, leave that first paragraph about preparation.
No, last part, your lord. At Pallada, we went to the sub-treasury office and reached there at 11:30 a.m. In the treasury office, a treasury clerk was trapped by the vigilance police. There was a gathering. Apart from this, I cannot say more about the occurrence. Now, your lordship may kindly come to page 76, para 4. I cannot identify the person who was trapped. I cannot say if the...
Oh, that means he totally not supported the prosecution case.
That is why the only person who can say about the occurrence is the complainant. Whether the complainant is a truthful witness and this circumstantial evidence supports his plea or not.
Okay, recovery part, as it appears, there is some discrepancy. But what have you elicited about the demand part?
That's right. Well, in order to appreciate that, you will also may kindly see the background circumstances. Why I am giving emphasis, my lord? The entire allegation of the prosecution is contradicted by the documentary evidence.
He said, Mr. Das, he said that the bill of rupees 90,800
yes,
in the name of my mother. The father died on so and so date.
My lord.
Then the bill of 90,800 in the name of the mother was sent from the block office Palhada to the sub-treasury for drawal of death gratuity and provisional arrear pension.
My lord.
So
that part is not disputed. Not why it is not disputed. That dispute is in respect of the debt. Kindly, in this respect, your lordship, may kindly come to FIR. FIR has page 57. Because he has omitted all these things regarding the rates in the evidence. The FIR discloses, second paragraph I am reading out. Thereafter, gratuity and area provisional pension bill amounting to rupees 90,800 was submitted to the BDO Palnawada. On 1/11, this date is very important. On 1/11/2003, to the sub treasury along with the provisional pension bill of my mother. Though provisional pension bill was passed by the treasury, the other two bills were returned to the block office. Being aware of this, I went to the treasury on 3/11/2003. Wrongly, it has been written on 31. And made the dealing clerk Sri Behra. Seeing me, Sri Behra became angry and charged for non-payment of the balance amount demanded by him earlier, and warned me, saying that he is not going to process it any of our bills if demands are not fulfilled fast. He demanded bribe of rupees 1,500 from me to process the bills and did not listen to my request. On 4/11/2003, I again met him in his office and requested him, but he remained firm on his demand. Finding no other alternative and under compulsion and against my will, I paid him rupees 400 there, which was with me. I took the same, asked me to get the bills resubmitted from the block office, and came up with the balance amount of rupees 1,100 on 14/11/2003 and pay him in his office. He made it clear that he will not process the bill unless the amount is paid by him. The bill has been resubmitted to the treasury by the block office on 10.
What, according to you, is the discrepancy?
My lord, your lordship may kindly see the bill, the original bill is under Exhibit 14. Exhibit 14 is the bill.
Exhibit
There are
14.
two bills, 350 and 351.
Just a minute. Exhibit 14, Bhargav. Yes, got the Exhibit 14.
14. There are two bills,
madam.
One is 451 and another is 450.
451, that is 71,000 or something.
Yes,
like
71,000.
And what is 450?
19,800.
450, that is 19,000. Yes. What do you want to say?
Kindly see the sub-treasury of the seal of the sub-treasury office in the left hand. Bill received in the treasury on 11/11/2003.
$450.
In both the cases, seal of the treasury, sub-treasury has been affixed, and the date mentioned is
14 লেখা ହେଇଛି କୋଉଠି ପାଇଲେ ଆପଣ?
left, my lord, here. The round seal of the sub-treasury office, left hand.
What is the date you say?
11/11/2003.
Okay.
I will come to the evidence also in respect of that, my lord. Now, below that, your lordship may kindly see the examined and entered treasury accountant. Treasury accountant
11/11/2003.
My lord.
But little below that, there is a date 27/10/2003. That very page.
No, that might be in the block office, but the treasury received on 11/11. Before that, treasury has not received.
Same seal is available in the. This is 71,000.
My lord.
The other one was also same.
Same. In the seal One is 450 has been numbered as 76. 11/11/2003. Your Lordship may kindly see the bill number 450.
I'm just 450.
My Lord, the treasury seal, the oval shape seal,
11/11/2003.
top of it 76, number 76. Now your Lordship may come to 451.
451 back.
77 11/11/2003.
This is 451 right in the top. 11/11. Yes.
My Lord. Your Lordship may kindly come below that. Examined and entered treasury accountant. There is typewritten, and against that there is a signature. Accountant put his signature. The left side below.
Left side say seal lo tole.
Out tole. Examined and entered treasury accountant. Just above the for use in the AG office.
को पोर्शन मते बुलेगी देखेले examine and enter treasury accountant. Yes.
That is the treasury accountant. In both the cases, accountant had put his signature, and the date is relevant 12/11/2003. In both the cases. 12/11.
Yeah.
Just right hand side, just to the right, treasury officer 14/11.
Got it.
In this context, you also may kindly come to the evidence of PW5, the treasury officer at page 87. I am continuing in the aforesaid post since 2002. I am reading out the cross-examination part.
Yes.
I was continuing in the aforesaid post since 2002. I had acquaintancy with the accused in the official capacity. So far, I know the conduct of the accused was good. None had lodged complaint before me against the accused in relation to his work. To my knowledge, the bill in question was approved on 14/10/2003 by me on being placed the file by the accountant on 14/10. My Lordship, it is very important. The file being placed the file by the accountant on 14/10/2003. The bill file dealt by the present accused was already sent to the accountant on 12/10/2003, which is evident from the exhibit 14.
No, you are in the office of
Sub-treasury.
Sub-treasury.
Right.
So BDO sent that document
to the treasury.
Right.
Treasury received on 11/11.
Right. Then your role comes.
Yes.
According to if we go those stamps and date mentioned therein, then obviously since the document had not reached the office of the Sub-treasury, prior to 11/11/2003.
My lord.
You mean to say that the demand of the appellant to the complainant on 3/11 and 4/11, that is a doubtful feature.
There is no cause of action. I am now, your lordship, I am bringing to your lordship to notice the evidence of TLO. TLO is PW4. His evidence starts from 78, but the relevant paragraph which I want to place, that is at page 84. Paragraph 8. I cannot say who identified the informant with the trap laying party, as I do not remember at present. It is a fact. Exhibit 2. Exhibit 2 is the preparation report. Exhibit 2 reveals that the alleged bill was received by the Office of the Treasury from the block office on 10/11/2003.
But the seal was 11/11.
Seal was it. Now, further, your lordship may kindly come to.
In the FIR, he said that it was already sent on 1/11/2003. That is
in view of the document.
In the view of the documentary evidence.
Now, your lordship may kindly see paragraph page 81. The same TLO. Evidence of the TLO. Fourth line from the top. The sentence starts with the wording, the accused stated. The accused stated that he had passed the bill number 450 amounting to 90,880 and bill number 451 amounting to 71,000 of Manjari Sahu, and he has processed the bill files on 12/11/2003 and had put up before the Treasury officer through the Dushasan Naik. Dushasan Naik is the accountant PW6. The accountant, and the said bill was sent to the Treasury officer on 14/11/2003. What the TLO says, that is being corroborated by the accountant as well as the Treasury officer. And the document is also proves the said fact. So, what is the cause of action on 3/11 or 4/11? Why should I demand more? What work was pending with me? I have already processed the file and placed it for the accountant. Accountant has
by that time, the file had not come to your office. Where is the question of processing?
No, after receipt.
No, after.
It was received on 11.
No, the initial demand.
3/4, there is no.
No, that is exactly. So, then the next date comes, the relevant date is, what is that date? 14/11.
13 he lost the FIR.
13 he lost the FIR, 14/11. But the evidence has come that the work has already been
before lodging of FIR.
That is on 12. So that endorsement of the accused is there in that two documents which you placed that
Exhibit 14.
That it was processed on 12/11/2003. Let us come to that document once again. So, Exhibit 14 exhibit list. This man is one date is there, 12/11. It appears, but it appears to be that of Treasury accountant.
ସେଇଟା କିନ୍ତୁ ତାଙ୍କ ସିଗ୍ନେଚର ସେଇଟା ତାଙ୍କ ସିଗ୍ନେଚର
କାହାର
ଆକ୍ୟୁଜ୍ଡ
he was the Treasury accountant.
ନାଇଁ ସେ ଆକାଉଣ୍ଟାଣ୍ଟ ନୁହେଁ ସେଇ ଜାଗାରେ ଇଏ ସିଗ୍ନେଚରଟା କରିଛି ଏଣ୍ଡ ସେ ଆଡମିଟେଡ୍ କେସ୍ ବାରରେ ସେ ଦେଇଛି ବୋଲି ଆଡମିଟେଡ୍ କେସ୍ ତାର ସେ ନିଜେ 313 ରେ କହିଛି ଯେ ଆମେ ବାରରେ ପଠେଇ ମାନେ 2 ଦିନ ପୂର୍ବରୁ ପ୍ରାପ୍ତ 2 ଦିନ ପୂର୍ବରୁ ଏ କରିଛି ବୋଲି
ଆଚ୍ଛା so that is what he is submitting, that suppose he had demanded the money he had received a part and the date was fixed to 14th for the payment of balance amount. Then it was expected of him to wait at least till 14. How he passed that is
I'll
his,
clarify. Let him complete.
No, that is exactly how then he passed it previously prior to the receipt of the bribe money. Or in other words, his submission is that since he has already passed, which is also a documentary proof that shows that there was no such demand. That is a submission. Yes, Mr. Das.
Now,
You have given your written note of argument.
no, I have not submitted because I can, if my lord's argument
No, that was
necessary that I can incorporate something.
That is exactly the reason why the matter was also adjourned. Apart from fixing the date for further hearing and supplying all the exhibits to both of you, there was also a direction that you should exchange your notes.
I am ready with the note because if any explanation is necessary, it can be incorporated.
No, that is exactly what you are arguing, that first of all, about that the date on which the first demand was stated to have been made and on the next day a part of it was accepted. By that time the file had not come to the sub-treasury office. That is on 3/11 because it came on 11/11. So the occasion arises only after the file reaches.
Yes.
That is your submission.
So
Then
in that case, if there is no file, why you will come to me on third? And why you will pay me 400 rupees on
No,
fourth?
that is exactly. Then next comes, suppose you said on third that after receiving on fourth a part of it, you fix the date to 14th for the balance payment, receiving the balance bribe amount. Then how did you clear the file at your level? Ordinarily, it is expected that you would have held
Keep
it up
pending.
for at least till 14th and then did anything. So the clearance of the file at your level on 12th indicates that you are not expecting anything to get on 14th. That was the next.
That is also spelled out from the preparation report. Well, also kindly see the preparation report. Preparation report, page 2.
That is exhibit is?
Exhibit 2. One line from the top.
Yes. Just a minute. Yes, exhibit 2.
Exhibit 2, page 2, your lordship may come.
Page 2, okay.
One line from the top. The bill had been submitted to the treasury from block office on 10/11/2003.
Yes.
This plea is not taken at the time of trial, but it is revealed from the preparation report. At that time, I was
the
there.
bill, please press it. The bill has been submitted to the treasury
From the block office on 10/11/2003. That means at that time, at the time of preparation, I was not there. Whatever the complainant or other witnesses have stated, that has been incorporated in it. From their statement, it appears that the bill was submitted on 10/11.
Then this overhearing witness are not supporting.
No, he has not supported.
Then place of recovery.
That is also discrepant
is
in view of the
discrepant.
evidence of PW1 complainant himself.
Once he said that he kept it in the Almirah, but
In
in
process
the process that it
stages.
was recovered from your possession.
2 stages he had stated so.
But TLO and other official witness stated about it was recovered from. To prepare the note and give it. Will you? Yes, anything?
Your lordship kindly see the FIR. Page 57.
No, you are not disputing these formal dates. Let us be clear on it.
No, date ta mu dispute karune.
So according to the prosecution, when the documents reached at the sub treasury office regarding payment, that date according to you, what he says that it reached on 10th, but the seal that was given on 11th. So is the prosecution disputing the same?
I'm not disputing on that point. My case is something different. I have something different to say. Your lordship kindly see. The exhibit, the 14 says, the bill in question was sent by the BDO, the FIR. It says, BDO sent it on 27/10/2003, 27/10/2003 to the treasury. Document says. It was then your lordship kindly pause a moment and then come to the gratuity and area provision pension bill amounting to 90,800 was submitted by the BDO Palohara on 1/11/2000 to the said sub-treasury along with the provisional pension bill of my mother. Though provisional pension bill was passed by the treasury, the other two bills were...
You are reading from the FIR.
FIR.
Please come to the evidence whether he has stated that.
Your lordship kindly see. Straight away I am coming to your lordship. 4 तारीख दिन incident टिके देखन. On 3 तारीख demand was made. 4 तारीख अछि. I again met him in his office and requested him, but he remained firm on his demand, finding no other alternative and other compulsions. And I against my will, I paid 400 there, which was with him. He took the same, asked me to get the bills resubmitted from the block office and come up with the balance of 1100 on 14/4/2003. से ताकू कहिले तो बिल फेरिची तू रिसबमिट कर आउ 14 तारिख रेस्ट पैसा नहीं गया.
What are you placing that is not a substantive piece of evidence?
My lord, then your lordship come
to the evidence what he has stated.
Then it will lordship come to evidence. Evidence part, that is one coming to exhibit 2.
No. Evidence part come to the evidence of this PW1 with
PW1. Then your lordship kindly come to PW1. First of all, your lordship kindly turn to the that is 313 statement of the.
I have seen it, that statement.
Statement in during trial, he has not disputed that. So far as the earlier demand on 3 or 4 tariki, he has not raised that objection.
Where is that? Where is the question?
जो से कहू नहीं एठी जे मो ये लॉर्डशिप कैन पेज से जो तार जो स्टेटमेंट है पेज 67 को
67
पेज 67 39 तांकर जो प्ली था नहीं चन.
No, why you will tell that when your evidence is lacking in that respect? No. Unless you adduce evidence during trial that on such and such date rupees so and so, then the question would be put, then he would offer explanation. Unless
he is not disputing that he was not dealing with that file. He is not disputing that he has not accepted that 400, or he is not disputing that he has.
Where he has accepted that he has taken 400 from you.
No, he has not accepted that. I am not on 400. Then? I am on 1100.
Yes.
I am on 1100. On the date of incident, your lordship kindly see, ताको बापांकर 2 दिन पूर्व ताको फाइल पठेइथिली सेठी से कहउछन he has taken the plea, only plea. The money was thrusted in his pocket, and prior to the day, on the date of trap, prior to the 2 days date of trap, I have sent the bill to the treasury officer, the accountant. So he is not disputing that he was not dealing with the file. and he was supposed to deal with the file. And the complainant knows very well that he will deal with the file. He did not say that I am not dealing with that file. Rather, he said that you come with this money and try to resubmit the file and come with the money. And accordingly, the file was resubmitted thereafter.
ସେ ଯୋଉ 400 ଟଙ୍କାର ଯୋଉ
Na
question
400 ଟଙ୍କାରେ ମୁଁ ନାହିଁ, I am not on 400 because that is not ବର୍ତ୍ତମାନ ସେଟା ସେ ଦେଇନେ ସେଟା ଉପରେ ଆମର କିଛି କହିବାର ନାହିଁ. We are on 1100. 1100 so far as 1100 is concerned, demand part is very clear. Your lordship kindly see page 6, para 6, 69 complaint statement. Then we all the staff member Palada. Then I went inside the office of the sub treasurer office Palawada, being followed by witness Ravindra Kumar Behra. Then I met the accused. He asked me if he had brought the money. I answered in affirmative. Then I brought out the tented money 1100 from his left side shirt pocket, chest pocket, and gave the same to the accused. The accused accepted the same and kept the said money in left side pocket of his wearing shirt. Then he took the said money and kept it below some files of the steel almirahs.
No, you just stop, Mr. There.
Madam.
This particular evidence which has been stated by PW paragraph 6 is no doubt very material and it is clinching evidence. But simultaneously, we are to see that in this part of evidence, you are not getting any corroboration from PW3, the overhearing witness. His evidence is not there. Okay. Now, about handing over this money to him, this 1,100, then he accepting it and keeping the money in the first in the pocket and then in the almirah. This evidence is given a go by, I would say. Come to paragraph number 13 and 14 which he placed. He said that he himself inserted it in the, I had given the money in the shirt pocket. Again says that I do not remember the exact pocket in which I kept the said money. What does it mean? I kept the said money. If the witness says that I had given the money in the pocket.
I got your lordship's point. The thing is that so far as second part of the demand on the date of trap is concerned, that is well established, that was not dispelled. That was not dispelled by the in cross-examination. That is, on seeing him, he asked me whether he had bought the money. I answered affirmative, then I bought the total money. So here again demand on the date of trap. That was not dispelled anywhere. Number one. So far as acceptance part is concerned, so far recovery part of the concern, that almirah, your lordship is said by petitioner please that it was discovered from the pocket. Then your lordship kindly turn to documentary evidence. That is exhibit 3, that is detection report. Detection report where the petitioner has put his signature and it has been exhibited without objection. That is, your lordship kindly see the detection report.
You are right, Mr. Marana. The documentary evidence as well as TLO's evidence indicates that
it was recovered from
that almirah.
Almirah thako jo thako thako tolu baharichi.
Kintu apanakoro ଆଉ ଦିଟା ଷ୍ଟାର ୱିଟନେସ୍ ଅଛନ୍ତି, ଗୋଟେ ହଉଛି କମ୍ପ୍ଲେନାଣ୍ଟ ଆଉ ଗୋଟେ ହଉଛି ଓଭରହିୟରିଂ ୱିଟନେସ୍. ଓଭରହିୟରିଂ ୱିଟନେସ୍ ହୋଷ୍ଟାଇଲ ହେଇଗଲା. ଆପଣଙ୍କର କମ୍ପ୍ଲେନାଣ୍ଟ ବା ଡିକୟ ସିଏ କହିଲା ଯେ ଟଙ୍କାଟା ସାର୍ଟ ପକେଟ ରୁ ବାହାରିଲା,
ମୁଁ ରଖିଥିଲି
ମୁଁ ରଖିଥିଲି ଯୋଉଟା ସାର୍ଟ ପକେଟ. ତାହେଲେ ଏଇଟା ଆପଣଙ୍କର ଯୋଉ ପ୍ରସିକ୍ୟୁସନ କେସ୍ ଟା, ଇଜ ଇଟ୍ କନସିଷ୍ଟେଣ୍ଟ? ଇଜ ଦି ଏଭିଡେନ୍ସ ଅଫ ୟୁର ୱିଟନେସ୍ ପ୍ରସିକ୍ୟୁସନ ୱିଟନେସ୍? এটা ডিফেন্স কোশ্চেন. ଆପଣ ଯୋଉ ଏଭିଡେନ୍ସ ଆଣି କୋର୍ଟ ସାମ୍ନାରେ ଥଉଛନ୍ତି, you are keeping the version of PW1, PW3 and the TLO. ଏଇ ତିନିଟାକୁ ଆମେ ଦେଖିବା, ଅନ୍ୟକୁ ଯିବା. PW3 ଟୋଟାଲି nil. PW1 ର ଏଭିଡେନ୍ସ ହେଲା ଟଙ୍କାଟା ବାହାରିଲା ମୁଦାଲାର ସାର୍ଟ ପକେଟରୁ. TLO ର ଏଭିଡେନ୍ସ ହେଲା ଟଙ୍କାଟା ବାହାରିଲା ଯୋଉ ଆଲମିରା ଭିତରୁ. କିନ୍ତୁ ଆପଣ ଯଦି ଦୁଇଟା ଏଭିଡେନ୍ସ କୋର୍ଟ ସାମ୍ନାରେ ରଖିବେ, then which version the court would accept, particularly when the accused has taken a plea that it was recovered, it was inserted by the accused in my pocket and it was recovered from my pocket, and that is supported by the complainant himself. He said that I kept the money in the pocket and I was, you come to paragraph number 17 him, that page number 72. Second line, paragraph number 17, page 72. I was present at the office veranda at the time the money was recovered from the shirt pocket of the accused. So ଗୋଟେ ଜାଗାରେ ନୁହେଁ, ସେ ତିନିଟା ଜାଗାରେ କହୁଛି। ଗୋଟେ ଜାଗାରେ କହିଲେ ମ୍ୟାଟର ଇଜ ଡିଫରେଣ୍ଟ, ଯେ ସ୍ଲିପ ଅଫ ଟଙ୍ଗ ହେଇଯାଇଥିବ। ତିନିଟା ଜାଗାରେ paragraph 13, paragraph 14 and paragraph 17 ଯୋଉଥିରେ ସେ କହୁଛି ଯେ ଆପଣ ସେ ଟଙ୍କାଟା ରିକଭରି ହେଇଛି ସାର୍ଟ ପକେଟରୁ। କେବଳ ସେତିକି ନୁହେଁ, ସିଏ କହୁଛି ଯେ ଯଦିଓ ଚିଫ ଏକ୍ସାମିନେସନରେ ସେ କହିଛି ଯେ ମୁଁ ତାକୁ ଟଙ୍କା ଦେଲି, ସେ ଟଙ୍କା ଗ୍ରହଣ କଲା, ତାପରେ ନିଜ ସାର୍ଟ ପକେଟ ରଖିଲା, କିନ୍ତୁ କ୍ରସ୍ ଏକ୍ସାମିନେସନରେ କହୁଛି ଆଇ କେପ୍ଟ ଦି ମନି ଇନ ଦି ପକେଟ। What does it mean by I kept the money?
Suppose the complainant give the money in trusted in his money in his pocket. For sake of argument, it's admitted for sake of argument that it was trusted by the complainant in the pocket of the appellant. Then there also he said that after taking the same, he kept the same in the almirah. Then your lordship kindly see that is the statement, 313 statement, para 27. It transpired, page 65. It transpired from the evidence of PW4 and 8 that the 1010 notes, your both hand wash, bottle container, shirt pocket wash, bottle container, cotton wash or bottle container for office almirah, and the cheat paper containing the serial numbers and denomination notes noted earlier were seized on different seizure list. Yes. Yes. That has been seized.
कौन है
तामाने एटी almirah जो cotton wash ହେଇଛି, that was in his presence and detection report was prepared in his presence, and circumstantial only because there are some discrepancies and money was recovered from from the almirah. Not only TLO, the circumstantial the seizure place of seizure list also says that is exhibit apart from the detection report, exhibit 12. Exhibit 12 says that is that are other two official witnesses. One is in the main, one is dead. Yes, he could not be examined. So सेठी से कहते claim almirah रे सेटा बाहरी बोली. So the आज भी कर the
what defense witnesses you have examined?
Myself.
What is your let us see your evidence. If 102.
I am the accused in this case. I had occasion to know the complainant Mohendra Kumar Sahu prior to 6 months of initiation of this case. He used to represent himself as a political person. He was very often coming to our office, taking work of various people prior to initiation of this case. He was threatening various employees of our office to perform the work of the people. In one occasion, I have protested such activities of the complainant. There was hot exchange of words between me and the complainant in our office. I warned him not to come to our office to pollute the environment. He threatened me to see him in future. On 14/11/2003, around 11:30 a.m., while we are sitting in our office room and performing office work, the complainant came to our office, took in her hand, and within a fraction of a second, thrust some currency notes in my chest pocket. I registered my protest in asking him what he has done. The complainant, without listening me, fled out from the office room. At the nick of the moment, a vigilance official came and got hold of me. They challenged me for taking bribe. I denied. They have asked me to bring out the currency notes. I brought out the currency notes from my pocket, which are thrust by the complainant. They asked me to count the money. I counted. It was about 1100. They took my hand wash. They asked me about the consent file, which was which they had seized from the office table of the treasury officer. I had looked at the file and replied to the vigilance officer that after completing my job, I had already returned the said file to the treasury officer on 12/11/2003. I had stated all the above details to the vigilance. At this stage, you will also may kindly come to the detection report. The detection report on the spot itself discloses this fact. It's not plea of afterthought. Detection report.
Detection report, he has taken plea that it has been thrusted.
Yes, all through. I have taken
Immediate
that
plea, your lordship kindly consider. The immediate plea was it was forcibly thrusted. No plea that there was no work with him. There was no demand from him. It was forcibly thrusted. Then your lordship kindly turn to his statement, page 76, cross examination.
Whose statement?
The overhearing witness statement. Though he has not corroborated the turn hostile, some portion of he has admitted. Page 76, your lordship.
Yes.
I had put my signature. That is that says the page para 3 ro just upper 2 lines. I had put my signature on each page of the detection report. This is my signature. He was not disputed that. Then para 4, cross examination. I cannot identify the person who was trapped. I cannot say if the accused stand in the dock in the person who was trapped. The vigilance police brought out the tainted money from the official mail.
No, you continue.
That part. So far as that part is in favor of the prosecution. And your lordship then come to, and the plea of the petitioner from the very immediate plea was it was thrusted. Had it been thrusted, he could have thrown it.
No, this one thing you by placing this evidence of the hostile witness, that is overhearing witness, you said that
the detection report is not disputed.
He put his signatures in different.
The detection report.
He said in cross-examination that I cannot say the contents of any of the documents in which I had put my signatures. The documents which I had put my signatures were not prepared in my presence.
Kintu ei para 4 re kahichhanti the vigilance police brought out the tainted money from the office almirah.
Yes. Well, that one line you see
no, the question is where the money is recovered.
Entire evidence has to be read as a whole. Not that this particular line is in my favor, I will take it. This is not in against me, I will just omit it.
Your lordship knows better than your lordship past experience. Your lordship knows.
So the question is
the evidence of the hostile witness cannot be discarded in entirety. And so far as your lordship, the plea is very pleased that he has thrusted the money in his pocket immediately. Now he is taking the plea that so far as the work part is concerned, there was no work pending with him. That was not the plea, so it cannot be accepted at this stage. And the thing is that he had the money thrusted with him in his pocket. He could have thrown it. And your lordship kindly see the next paragraph. He stated that he could have stated that is took the money below the official. And it's a କହିଛନ୍ତି they mate pore dei parthante rakhantu boli subsequently daba pai କହିଛନ୍ତି. That is then para 14 cross examination. The said the GC note recovered from the pocket of the accused was telling me at that time of giving money that I should give that said cash subsequently. That means he has deliberately accepted the same, knowing that it is not a legal remuneration or legal money, it is a bribe amount. Para 14 of the complaint statement. So it's a deliberate acceptance, knowing fully well that it is not legal remuneration, and so far as the place of seizure and exhibit documentary evidence, my respectful submission is, and in view of the TLO statement and other, when the acceptance, recovery and acceptance and recovery is there, he has, and demand part is there on the very same day or day of trap, he has also met the demand. And it is no doubt, it is also admitted fact that he was dealing with the file. And the petitioner has no opportunity, no whether the file has been handed over to the, and he told the file on the, told that you come with on 14th, and by that time he completed the work, and petitioner has no opportunity to know the whether this work has been completed or not.
No,
He himself, complainant himself has deposed.
he's pursuing the file of his father's dues, which is to be got by his, which is to be received by his mother. So it is expected that he must be visiting different offices, whether the file has gone from BDO's office to the sub treasury or not. So you say that how can he know the, because documentary evidence indicates that it was received on, the stamp is at least on 11th, but the oral evidence is on 10th. So that means right, 11 whatever.
No, the
So-
complainant himself has admitted, paragraph 13, on the date of occurrence, the accused had told me that our work has already been done.
The thing is that it is not disputed he was not dealing with the file. Knowing fully well that he will deal the file, he might have demanded. And on the date of trial, he could have stated that why are you giving money? He could have, if the money
Yes,
is
that was
trusted,
my plea.
it's a general presumption.
That was
It's
my
a
plea.
general presumption. It's not. It's a presumption of law under law, and he has to rebut it under what circumstances the money was recovered from the
ଆପଣଙ୍କର
admiral.
ଯୋଉ complainant ଗୋଟେ particular line ଯୋଉ କହୁଛି ତାପରେ importance ଦିଅନ୍ତୁ. Complainant କହୁଛି paragraph 3 ରେ ଯେ accused told me that unless I give him rupees 1,500, the bill will not be passed. ତେଣୁ ସେଥିପାଇଁ 400 rupees ଦେଲା, 1100 rupees ଏଇଆ ଯଦି ହଁ ତ
That means
1100 ଟଙ୍କା ଆଉ ବାକି 1100 ଟଙ୍କା ନଦେଲେ ତ ବିଲ୍ ପାସ୍ ହେଇପାରିବ ନାହିଁ, ତାରିଖ ଧାର୍ଯ୍ୟ ହେଲା 14 ତାରିଖକୁ। ଏଇ ଲୋକ ଯଦି ଏଇ ଟାଇପ ର କହିଥିଲା 4 ତାରିଖ ଦିନ, ତାହେଲେ ସିଏ ଫାଇଲ ଟାକୁ କେମିତି ତା ପାଖରୁ କ୍ଲିୟର କରିଦେଇ ପଠେଇ ଦେଇଥାନ୍ତା 5 ତାରିଖରେ।
your lordship, then
If he was expecting to get the money,
if he had
40.
sent the file, he had no intention to accept the bribe or demand the bribe. On the date of trial, he could not have accepted the money. He could not have asked for
That
demand.
you said that accepted, but the
Demand is there.
Your witness said that I kept the money inside. What is the acceptance?
Your lordship can see his statement.
He has stated in chief examination, I handed over.
Dispelled.
Oh God. Come to the paragraph 13, 14. I am again telling you.
14
In
your
paragraph
lordship
14, he said,
My lord.
13 you come.
13 I got your lordship's point. 14
So,
your lordship can come.
When your witness says that I kept the money in the pocket, so where is the question of accused taking the money, counting and keeping it?
Then I'm satisfied, your lordship. Suppose somebody will come and thrust money on my pocket. You have no intention to accept. On the other hand, I'm saying that you give it subsequent. You could have given me subsequent.
All these things happened in a fraction of a second. The moment it is done, vigilance got the signal, immediately rushed to the spot. There must be some time. Somebody must, what has happened to me? So immediately you say, now sitting at SC chamber, you are thinking that why he has not done that. He must be so many things why a person is reacting in a particular manner.
Your lordship kindly visualize things. Suppose he had no intention to accept the bribe. The complainant came, forget about that demand part. He asked about the money.
Once you forget the demand part, your case
No. I'm satisfying your lordship.
Prove all the three: demand, acceptance, and recovery.
So far demand part is
forget, no question of forgetting.
No, but demand part is not disputed now. Demand part is.
You are telling that it is not disputed.
Then your lordship kindly turn to page 6, para 6.
Yes.
Demand part is on seeing him on the date of trap. He is asking about the money. He is asking about the money, and when he is told the affirmative, then he bring the money from his pocket and thrusted in his pocket, and he accepted it. And so far as prosecution story is concerned, he accepted it. Then he kept it in the almirah. Then your lordship kindly turn to cross-examination. Cross-examination, your lordship's point by appellants feel that he thrusted the money in his pocket. Then para 14 says GC note were recovered from the pocket. There may be some discrepancies. The accused was telling me at that time of giving money that I should give the said cash subsequently. That means se kohuche mu subsequently mate debo pore debo. That means he is deliberately accepting it. And the work was completed or not, that is that plea, that is not a ground to dispel, that is not a ground to discard the story of the prosecution. That is the judgment. Law part to your lordship will permit. I'll go to the law part on each and every aspect.
Okay. So file your written note of argument.
I have given my written notes of argument
Let us see
yesterday.
that written note of argument.
One thing I will bring to lordship's notice.
Hard copy of the
First thing, the PW1 has not been declared hostile. Even though he has resigned from the statements in the chief.
After that also he could have resigned. He could have declared hostile.
And he himself admit that there was animosity in paragraph 11.
You see, Mr. Maharana, what is driving it? Suppose in the chief examination, he stated, I handed over the money, accused counted, kept it in pocket. In cross-examination, he is telling that I kept the money in the pocket of the accused. Two contradictory statements when it is coming, then you should have filed an application to re-examine the witness and get the clarification as to which one is the correct. You said in the chief examination like this, and you are telling in the cross-examination like this. That is exactly the purpose of re-examination.
137.
I got your lordship's
So
point.
when you are not doing it is completely contrary. The chief is cross-examination is contrary to the regarding. No, that is exactly. So what is
what I am submitting, it's not a case that he has not demanded or he has not dealing with the file. So there is no work with him.
See, in a case of this nature, mainly basing on the statement of the complainant, the shadow witness or the over-unit and the TLO. Mainly the conviction or the...
Your lordship. So but thing is that what I respect to humbly submit that thing is that so far there are some minor discrepancies on the part of the part of the complainant statement. So far a demand, acceptance, recovery part is concerned, there are documentary evidence, other witnesses evidence and factual circumstances. So clearly show that there was demand, acceptance and recovery. And the other aspect is concerned so far a minor discrepancies, but discrepancies on the statement. On the discrepancies of the on the plea taken by the petitioner is that petitioner immediately took plea of the petitioner that it was money was trusted. Only plea was money was trusted. My respectful summa, had it been trusted, money could not have been recovered from the Almira and he could have thrown it. He could not have stated that you could have given it a subsequent stage. So it amounts to deliberate acceptance of bribe, knowing that it is not legal remuneration. So on that count, I have given the notes and your lordship kindly and petitioner the time and time he is taking differently. Your lordship kindly see, and it was not the case that the petitioner. So far as
your witness is taking different, making different
there is some
statement.
discrepancies.
That will not.
I am too admit at this stage. There is discrepancies. But the thing is that it's a case of corruption.
You prove your case beyond all reasonable doubt. Then burden shifts to him to prove the case beyond by preponderance of probability.
So now so far in view of the acceptance and the recovery and demand, then the presumption under section 20 comes and he has to review the presumption. He has not dispelled that presumption with a plausible explanation. How the money come to his pocket? He is only saying that it was trusted. Had it been trusted, so it could have been thrown away, or he would not have stated that he would not have demanded.
What is that seizure list of money?
Seizure list, your lordship kindly see page exhibit 12. Page.
Just a minute. Let me find it out.
Lordship got it.
The ticket. 11. exhibit 12 तो
exhibit 12
exhibit
12 ନୁହେଁ
12
12
exhibit
ନୁହେଁ
12 ଟା ହଉଛି କଣ ଲେଖା ହେଇଛି one sealed bottle containing pink
ନାଇଁ
color
12
ନାଇଁ ନାଇଁ exhibit 12 12
ନାଇଁ
ଏଇଟା ପା କୋଉ କହୁଛନ୍ତି ଏଇଟା ପା କହୁଛନ୍ତି
no it's not 12 at least
12 para 5 টা circumstances of seizure in connection with the investigation of the above noted case after detection of case and Ghasiram Behra junior clerk so and so his office almirah in which he kept the tainted money received from the complainant under the
अरे
death of a
कौन टा
child
जब्बत ହେଇଛି ଦେଖୁନାହାନ୍ତି
again
आर्टिकल 4 नंबर ଟା ଦେଖନ୍ତୁ କଣ ଜବତ ହେଇଛି
ହଁ one sealed bottle containing pink color solutions and cotton blue at the wash of the office
2000 ଟଙ୍କା ଟା ରିକଭରି ହେଇଛି ମାନେ କାହିଁ ସେ ଡକ୍ୟୁମେଣ୍ଟ ରେ ଏଇ ଯୋଉ ଆର୍ଟିକଲ କଣ ଜବତ ହେଇଛି ଆମେ ତ ଦେଖିବା ଆଗେ ତାପରେ ପ୍ଲେସ୍ ଅଫ ସିଜର
ତାପରେ ଏଇଟା ତା ପୂର୍ବରୁ ଦେଖୁନାହାନ୍ତି ଏଇଠି ପା ତଳେ ଲେଖା ହେଇଛି circumstances of seizure
ଏତେ circumstance of seizure ଛାଡନ୍ତୁ ଆର୍ଟିକଲ ଟା କଣ ସିଜ୍ ହେଇଛି where it is mentioned that 2000 rupees was seized in this article seized
that is
and
other seizure list are there
exhibit 5
exhibit 5
ହଁ ମତେ କୁହନ୍ତୁ ସେ ଯୋଉ 2000 ଟଙ୍କା ରିକଭରି ର ସିଜର
exhibit 5
exhibit 5 let us come to that these two witnesses have been examined
ନା ଜଣେ ତା ଭିତରୁ
Dilip Swai Rabindra Behra who are the
ଦିଲ୍ଲୀପ
witnesses
ସ୍ୱାଇଁ ହେଇଛନ୍ତି କିନ୍ତୁ ରବୀନ୍ଦ୍ର ବେହେରା ବୋଧେ ଇଏ ମରି ଯାଇଛନ୍ତି ନାଇଁ
Dilip
ନାଇଁ
Swai
sorry ଗିରୀଶ ଚନ୍ଦ୍ର ରଥ ମରିଛନ୍ତି ରବୀନ୍ଦ୍ର ବେହେରା
अरे बाबा ଏଇ ଯୋଉ ସିଜର ଲିଷ୍ଟ ର ଯୋଉ 1100 ଟଙ୍କା ଟା ଯୋଉଟା ରିକଭରି ହେଇଛି ସେଇଟା ଯୋଉ ତା ଦେହରେ ଦିଟା ସାକ୍ଷୀ ଅଛନ୍ତି ନା
ରବୀନ୍ଦ୍ର ବେହେରା is the overhead witness PW3
so he has not supported then
ଦିଲ୍ଲୀପ ସ୍ୱାଇଁ
Dilip Swai
PW8
support କରନ୍ତି
PW8
PW8 let us see that PW8 evidence of her junior clerk emergency so and so এটা গলা
para 5 ରେ
para 5 with the hand wash of the accused being taken separately gala the complainant had told that so and so brought the tainted from the kept it so and so फाइव टाकू सीए प्रमाण कोठी करेला एग्जिबिट 5 रे तार सिग्नेचर
exhibit 5
Yes, paragraph 7
7 this is the seizure list of so and so okay what has been stated in the cross examination
cross ରେ he has not supported
this very same statement has been disowned
cross is not supported
kindly your lordship kindly the middle portion of paragraph 5 the complainant and Orient witness told that the accused receiving the bribe money kept in the same in his shirt pocket first and then he kept inside his office almirah witness Girish Chandra Ratha brought out the tented notes from the said almirah which was kept there in between bundle 5 now your lordship may kindly come to cross examination paragraph 9
yes 9
in the middle he starts with I had not stated before the vigilance police. Your lordship got it, right?
I had not
1 2 3 4 5
tell me the lines from the
ninth line from the
No,
I
no.
had not stated before the vigilance police.
From the bottom or from the top?
From top. I am reading out the letter.
I had not stated before the
vigilance police
that
the
the
complainant and overhearing witness told that the accused receiving the tainted money kept in his side pocket first, and then he kept the said inside the office almirah, and the Rathababu brought out the tainted money from the inside the bunch of file.
Just a minute. This is page number. In paper book of who page कहले?
99. Page 99. Chief 97 and cross examination 99.
Yes, I had not stated before sworn, so did not. Okay.
Your Lordship knows the AR 79 Supreme Court Surajmal's case, where the witness makes two inconsistent statements. In their evidence, either at one stage or two stages, the testimony of such witness becomes unreliable and unworthy of credence. Both the complainant has made prevaricating statements, and even though the prosecution did not
This
declare
Girish Chandra Ratha has not been examined.
Not say the magistrate notice has not been examined.
No.
So, Mr. Das, I am closing it. When you will file your written note
tomorrow.
With if any memo of citation and go through it and just if you want to rely on evidence, just point out in that as per your
paragraph and page.
paper book ro page or paragraph ताको heading करिकिनी आपण देई दियंतु जे जो जेमती नो वर्क पेंडिंग बा जो डिमांड एक्सेप्टेंस हेडिंग रे शॉर्टली देई दियंतु तो लिखि दियंतु दी लर्न एंड काउंसिल हार्ड दी लर्न एंड काउंसिल फॉर दी appellant, learn counsel for the Mr. N. Maharan, learn counsel for the additional standing counsel for the vigilance department. He filed the written note of argument
along with
citations, which is taken on record. Copy of the same has already been furnished to Mr. Das. Earlier, na aji deisle. Acha, today in court, Mr. Das submits that will file the written note of argument and memo of citation by tomorrow, giving copy to the Land and Additional Standing Counsel for the Vigilance Department. Hearing is closed. Judgment is reserved. ये से जो ये कर देले कि जो लिख देला नो ऑब्जेक्शन बोली देखिले मुझे
much obliged.
Where is the counsel? Mr. Patnaik कोड गले अरे I have no objection करी ता तले signature मारिया कथा नहीं कौन सब कौन केमती accept कर दो जो माने you are such a I have no objection जी लिखिला से दस्तखतटा करिबो ना नहीं What can accept कर दो जो Where is Mr. Patnaik?
Lord, he took the lift.
Ask him to. He has written to in the consent memo. He has simply written, I have no objection, but he has to put his signature there. So that he has not done. So ask him to come and sign it. Okay. And ये Mr. Das को तो पूरा नाटा लिखिवे consent memo रे, है ना? दी जाऊँ कोई Yes.
Item 3, I humbly pray that the paper book to be served, my lord, kindly, and fix any date, my lord. I will argue.
Argue the matter. Yes.
Paper book is not there, my lord. That's it. Item 2, counsel.
Mr. Patnaik, put your signature. How you just wrote, I have no objection. Are skill kotha? Mr. Das sendi tang pura na likhi na dita je khali signature mar dijen. Mr. Das mu kahibe asigini tang pura na ta likhibe ta dere. Short signature margin jona purne na. I have no objection. Tali you put your signature and date. Date. No, you put the date when that was filed. At least you should give the date when it was filed. So prior to that, you yes. Just give the paper book to the Learning Council. And it is also a vigilance matter.
My lord, I'll receive the paper book. My lord, may fix any date. I will come and argue next week or any week.
How you are expecting an adjournment in 1999 matter?
My lord, I just paper book only till Friday at least. My lord, I'll argue on Friday. I have the entire brief paper book.
What is your good name?
Pratik Nayak.
Have you received or you will collect it?
I'll collect, my lord.
Hey, give him the paper book. Huh? No, extra office re thibo charta panchta set prepare huye. That is the requirement as per GRCU. So hand over him a copy immediately and ask the office to give him another. Okay. Mr. Pratik Naik, Land Council, appearing for the appellant, submits that he has not received the copy of the paper book, and let the office be directed to supply the paper book, and the hearing of the criminal appeal be taken up next week. Mr. M.S. Rizvil and an additional standing counsel for the Vigilance Department, which to argue this appeal is present. Let a copy of the paper book be handed over to Mr. Naik during course of the day. Put up this matter, since it's a matter of the year 1999. The criminal appeal is of the year 99. Place this matter on 20th of January 2023. And it is made clear that no further adjournment shall be granted. Yes. Receive the paper book from the court and put your signature here. Yes.
Pardon me, my lord, date again, kindly.
It will be taken off on 20th of July 2023, next Thursday.
Obliged.
Yes.
Item 4.
My lord, on behalf of Liquor, kindly taken up next week, ma.
What is this matter?
My lord, kindly pass over.
Our paper book.
306-498A.
What is the operative part of the judgment, Mr. Tripathi?
Yes, running page 38.
of the paper book.
Paper book.
And the relevant portion is 40.
Just a minute. Page 40 you said?
Yes.
Okay, please place it. Let us see.
Keeping in view the society's reasonable expectation for appropriate deterrent punishment commensurate with gravity of the offense, the convicts are sentenced to undergo RI for 2 years and pay fine of 5,000. That in default 6 months more under section 498A IPC, and to undergo RI for 5 years and to pay fine of 5,000 in default RI for 6 months more under section 306 IPC. Each sentence are run concurrently.
So it's 5 years.
Yes.
Now let us see that what are the offenses under which charge was framed. Charge page is 49.
49. Yes.
So so many persons were facing trial.
Yes.
5 persons.
5 persons.
Okay.
Yes.
All of them were found guilty. Is appeal filed by? Yes, all the file. So the first one is Mr. Tripathi, you place the charges one by one. On 21st day of April, yes.
21st day of April 2000 at 8 a.m. at Bhuguda Kota, you being the husband and relative of the husband of Lakshmi Priya, subjected her to cruelty by willful conduct which is so of such a nature as is likely to drive Lakshmi Priya to commit suicide by demanding more dowry in furtherance of common intention, and thereby committed offence punishable under 498A by 34 of the Indian Penal Code within my cognizance.
Okay, then 304B.
Second, that you on or about the same day of 21/4/2000 at the same time and place causes dowry death of Lakshmi Priya by bonds within 7 years of her marriage, and it is shown that just soon before her death she was subjected to cruelty by you, all in connection with demand for furtherance dowry in furtherance of common intention, and thereby committed offence upon 304B by 34 IPC.
So it's a case of burn injury.
Yes.
Right?
Yes.
And PM doctor, as it appears, PW6.
6 million.
He has stated that injuries due to burn, age of injury. Okay. Now, next thing is that
there was a dying declaration.
Dying declaration is who has proved it?
Let me see.
When the marriage was solemnized? As per the FIR, it is mentioned.
Type computer disuni kichi oda.
FIR ଅଛି page number 45 ରେ paper book 45 କୁ ଆସନ୍ତୁ.
Yes, ma'am. 45.
ମାର୍କଣ୍ଡ ବେହେରା so and so 21 number ward ରେ ପୁଅ ସହିତ ହଁ. So marriage is in 1999. 13/10/19. Let us say 13/10/19, and occurrence took place on what date?
21/4/2000.
Right. Yes, 21/4/2000. That means a few months after marriage, this occurrence has taken place. No,
after 6 months.
6 months ago. All right, and it's a burn injury. So, and occurrence has taken place in the house of the accused person. Okay. After how many days of the occurrence or getting this burn injury,
Yes.
she died. And if any dying declaration has been made before the doctor or anybody else, is it a written dying declaration or oral dying declaration?
Written. She has signed it.
Okay. Then who has proved it? Another doctor is PW5.
Five.
I was in charge of someone admitted in the female surgery ward, 50% burn injuries.
Okay. Yes, well, the executive magistrate, PW4.
PW4?
Yes.
All right. Okay, please place it, let us see.
On 21/4/2000, I was working on executive magistrate come Tahsildar Baripada. As per direction of the SDM Baripada, I had gone to record dying declaration of the deceased Lakshmipriya Behera, wife of Prahalada Behera, village Bugudukota. I came to the hospital about 10:30 to 11 p.m. IIC town PS had accompanied me. Police identified injured Lakshmipriya to me. Lakshmipriya had been admitted into a female surgical ward. The entire body of Lakshmipriya had been blown. She was not in a condition to make any statement. In spite of that, I put her some question. She stated before me that she set her ablach by pouring kerosene on her body. She further told that her mother-in-law, aunt-in-law abused her since morning, and at about 8 p.m. she burnt herself. She further told that her husband and father-in-law had not scolded her. She further told that her marriage had been performed about 7 months back and that she was carrying 2 months pregnancy at the time. She further told me that none had told her with regard to dowry article expert scolding her. Though I had put several other questions, but she did not give any answer, and she complained that since she was giving severe burning sensation, she was not prepared to make any other statement. I recorded her statement by the Exhibit 7. Exhibit 7.1 is my signature. Exhibit 7.2 is the signature of Lakshmipriya Behera. Lakshmipriya was not in a normal state of mind at the time of making her statement.
No, perhaps that is the reason why he has been acquitted, the accused persons were acquitted of the charge under 304B. 4B because he said that none had told her with regard to dowry articles except scolding her. And scolding was by two persons, not by all. In paragraph 2, in the dying declarations, he stated that mother-in-law and aunt-in-law abused her since morning. And at about 8 p.m. ମାନେ ସକାଳୁ ମତେ ଗାଳି ଦଉଥିଲେ। ତ ଅନ୍ୟ ଯୋଉ ଫ୍ୟାମିଲି ମେମ୍ବର୍ସକୁ ଟ୍ରାଏଲ କୋର୍ଟ କନଭିକ୍ସନ କରିଛନ୍ତି ସେମାନଙ୍କର ବିଷୟରେ ସିଏ କହୁଛି she further told that her husband and father-in-law had not scolded her. ତାହେଲେ how they are responsible for abatement of commission of suicide? If only two ladies scolded the deceased right from the morning. And she said that is the reason why I burnt myself. Then how, and further stated that my husband and father-in-law had not scolded me. Then how they will be convicted under 306? And not only this, there is another person, 5 persons were facing trial. The judgment indicates 5 persons. This Prahlad Behera is perhaps the husband.
This first was the petitioner number 1.
କାରଣ ସେ FIR ମଧ୍ୟ କହୁଛି ମୋର ଝିଅକୁ ଗତ 16ରେ ବିବାହ ଦେଇଛି। Prahlad is the husband, right? So if Prahlad is the husband, then it appears that this Govinda Behera is the elder brother-in-law.
Elder brother.
Right?
Yes.
Then
petitioner
Draupadi
fifth
Behera is the
mother.
No.
Yes, mother of petition number 1.
Right. That means mother-in-law of the deceased,
Yes,
right?
yes.
Then comes
Or who is that?
Parameshwar Behera. Who is he? Let us go to the evidence of one witness. Who is this Parameshwar, Mr.
My lord, Khurtasura, FIR.
Khurtasura. Court paile.
FIR,
FIR ji.
Yes, my lord.
Let us see that. Who line ta kaile? It is Khurtasura Parameshwar Behera.
Yes.
All right. So now let us. I would rahila. ये जो नेक्स्ट हाउची कट्टी alias भारती बेरा
son of Parmeshwar.
तामने
sorry, wife
of परमेश्वर सो वर्तमान से ये टाकू पळे आसन आपण जो डाइंग डिक्लेरेशन रेकॉर्ड करला PW4 हला
yes
से आउथरे पढिबा
she
stated before me
she stated before me that she said her oblige by pouring kerosene on her body. She further told that her mother-in-law, aunt-in-law abused her since morning, and at about 8 p.m. she burned herself. She further told that her husband and father-in-law had not scolded her. She further told that her marriage had been performed about 7 months back and that she was carrying for 2 months pregnancy at the time. She further told that none had told her with regard to dowry article expert.
So, Mr. Tripathi,
yes,
come to the appeal memo. That is a part of the paper book, memo of appeal, page number 2.
Yes, madam.
You see there are 5 appellants.
Yes.
You got it?
Yes, madam.
That page. Page number 2 re.
Yes.
He is stating only against 3 or 5.
3 Draupadi Behera and Katti Bharati Behera.
3 टा होची mother in law.
Yeah.
आउ 5 टा होची से जो कोन
aunt in law.
Aunt in law, right?
Yes.
And he has not stated anything in the dying declaration about this appellant number 4.
Yes.
परमेश्वर विरुद्ध रे टोटल किछि कोइ
Totally नाही किछि.
आउ पॉजिटिव जिंस कहूची against in favor of 1 and 2.
Yes. Yeah, 2 को to 2 to 2
appellant number 2
father-in-law is not father-in-law.
No, 2 is not the elder brother-in-law.
Elder brother कुछ ता विषय तो किछ कहूनी से कुछ फादर-इन-लॉ को
अच्छा तार अच्छा ता माने दी जण को विषय टोटल किछि कहूनी गोविंद विषय परमेश्वर विषय टोटल किछि कहूनी प्रहलाद बेहरा विषय भलो कहूची जे समान छि गाली फाली करना. Okay, now this is the dying declaration. What the witnesses have stated. Let us go. The PW1 is Sudhanshu Giri.
Sudhanshu Kumar Giri.
वर्तमान डिमांड गुरका जहाँ सी एविडेंस देइची that is irrelevant because he has been acquitted and there is no challenge.
No, sir.
Right?
Yes.
Acha. Has he stated anything what happened just prior to that about that abatement? Kan apanagaro the conviction is under 306
yes.
and 498. So about the torture part, one thing, and about this abatement of suicide. Yes. So what he has stated?
PW2, the brother of deceased.
No, come to PW1 one yes. by one. Has he stated anything about that? Yes, in paragraph number 4.
8 days prior to the death of Lakshmi Priya, Markanda called me to his house and told to go to the house of the accused person. I accompanied him to the house of the accused person. When Markanda was discussing the matter with accused Parmeswara and Govinda, I entered into the room of Lakshmi Priya and she complained before me that the accused person were ill-treating her for not giving those articles. When other family members entered inside that room, Lakshmi Priya cried and did not disclose any other matter. At the time of our departure, accused Govinda assured us to settle the matter at their level. After 7 to 8 days our departure from the house of the accused persons, I got information that Lakshmi Priya had sustained burn injury. Injury Lakshmi Priya had been brought to DHS Baripada and thereafter she has removed to Tata Main Hospital. Subsequently, I ascertained that Lakshmi Priya died.
Now you come to the paragraph number 13, this very important
Yes,
lines.
It is not a fact that I had not stated before IO that 8 to 10 days before the death, I had gone to the house of accused persons and that Lakshmi Priya complained before me that she was being ill-treated due to demand of dowry.
So this was confronted, and whether it has been proved through the IO, because mere confrontation will not do, because he has denied. What about the other witnesses?
PW2.
Who is he?
Brother.
Brother of the deceased.
Yes, ma'am. Para 2. My father had gone to the house of accused Prahalada during Durga Puja to bring Lakshmi Priya home, but accused person did not allow Lakshmi Priya to come with my father. On 12/1/2000, I had gone to the house of accused Prahalada to bring Lakshmi Priya to our house, but she was not allowed to come. Accused Prahalada told that Lakshmi Priya would be allowed to go for delivery of all the
after delivery of all the dowry.
all dowry articles. When Lakshmi Priya wanted to come with me, accused Prahalada pushed her into the room and bolted the door. I had gone 4 to 5 times after 12/1/2000 to the house of accused Prahalada, but I was not allowed to talk with Lakshmi Priya as she was being kept in a room, bolting the room from outside. On 21/4/2000 at about 8 p.m., Lakshmi Priya had made telephone call to our house and requested us to take her back from the house of accused Prahalada, lest she would be killed. On that day, my father and Nakula Behera went to the house of accused Prahalada. Accused Parameswara Govinda assured my father to settle the matter in the family and to leave Lakshmi Priya after some days. On that day evening, somebody informed us telephone that Lakshmi Priya has been hospitalized due to burn injury. My father came to the Baripada hospital along with my mother and some other relation, including Nakula Behera. My father took Lakshmi Priya to Tata Hospital for better treatment. But finally, a family member of the accused person accompanied Lakshmi Priya to, but no family member of the accused person accompanied to Lakshmi Priya Tata Hospital. On 26 night, Lakshmi Priya died at Tata Hospital.
So the evidence of PW4 is important. The executive magistrate in the whose presence the dying declaration was.
We have gone through.
So
allegations so far as appellant 4.
Hmm.
No allegations so far appellant 2 and 4 are concerned. They are teachers. They are appellant 4 is the paternal uncle-in-law of the deceased.
No,
And,
that is so far as abatement is concerned. The evidence of PW 4, who has recorded the dying declaration, being the executive magistrate,
yes, sir.
that is relevant because
Yes.
she has only implicated two ladies, the
Two
deceased.
ladies, mother-in-law and aunt-in-law.
Right. So that may be one of the factor for, let us say that the other may not be entangled on for 306. That means the husband, the um, that
Elder brother-in-law and
elder brother-in-law and that
uncle-in-law.
uncle-in-law. So that is 306. But what about 498A? But they have also stated that they were torturing, and whenever they were going there, this things is happening. The star witness is the brother also has stated like that.
Father is also.
Father is PW
3.
3.
Para 6 married.
Yes, yes.
10 to 12 days prior to the death of Lakshmi Priya, I got a letter from my daughter through a female. Police seized that letter on my production by the seizure list number Exhibit 1 with my signature thereon. Police also seized the school hand note of the deceased along with the letter.
Letter has been proved.
Yes.
Exhibit.
After receipt of the letter, I went to the house of the accused person along with Sudhanshu and reached there at 8 p.m.
See, letter ta praman heichi na nahi? Eta seizure list ta.
Seizure list.
Letter ta exhibit heichi?
Exhibit 1.
Exhibit 1 ta seizure list ta.
Next week assume the out देखिए I have not properly.
Where is the exhibit list? Exhibit 1 is the seizure list. Dying declaration is exhibit 7. Court map. One handwriting plain paper letter without date and name written received, stated to have been given by the complainant by the victim daughter. Admitted handwriting so and so. So ଚିଠିଟା ଆପଣ ଯଦି ଜବତ କଲେ ତାହେଲେ ଫାଷ୍ଟ ହଉଛି ସେଟା ଡିସିଜ୍ଡ ର କି ନାହିଁ ସେଇଟାକୁ ପ୍ରମାଣ କରିବାର ଥିଲା। ଦ୍ୱିତୀୟ କଥା ହଉଛି ତା ହ୍ୟାଣ୍ଡରାଇଟିଂ ଏକ୍ସପର୍ଟର ଓପିନିଅନ ପାଇଁ ପଠା ହେଇଛି କି ସେଟା କିଛି ଜଣା ପଡୁନି। ଡାଇଂ ଡିକ୍ଲାରେସନ ଲେଖା ହେଲା that is marked as exhibit 7. ମୋର ନାମ ଲକ୍ଷ୍ମୀପ୍ରିୟା ବେହେରା, ମୋ ଦେହରେ ମୁଁ ନିଜେ କିରୋସିନ ଢାଳି ପୋଡ଼ି ଦେଇଅଛି। ମୋ ଉପରେ ଶାଶୁ ଓ ଖୁଡୀ ଶାଶୁ ବହୁତ ଗାଳି କରି କହିଲେ ସକାଳୁ ଠାରୁ ଗାଳି ହଉଥିଲା। ଆଚ୍ଛା, ମୁଁ ରାତି ପ୍ରାୟ 8ଟା ସମୟରେ କିରୋସିନ ଢାଳି ପୋଡ଼ି ହୋଇଛି। ମୋର ସ୍ୱାମୀ କିମ୍ବା ଶ୍ୱଶୁର ଗାଳି ଦେଇ ନାହାନ୍ତି। ମୋର ବିବାହର 7 ମାସ ହୋଇଛି, 2 ମାସ ହେବ ମୁଁ ପ୍ରେଗନେଣ୍ଟ ଅଛି। ଯୌତୁକ କିମ୍ବା ଅନ୍ୟ କଥା କିଛି କହି ନାହାନ୍ତି, କେବଳ ଗାଳି ଦେଇଛନ୍ତି। So ଏଇଟା ହଉଛି ତାର dying declaration that has been proved by the executive magistrate. So
demand of dowry.
Mr.
Yes.
Tripathi,
Yes.
ସେ ଯୋଉ ଚିଠିଟା ଗୋଟା କହୁଛନ୍ତି ସେ ଚିଠିଟା କେତେ ନମ୍ବର ଏକ୍ଜିବିଟ କାଇଁ ମତେ ପାଉନି?
ଚିଠି ହେଇନି ବୋଧେ,
ହଁ
ଖାଲି ସିଜର ଲିଷ୍ଟ
ସିଜର ଲିଷ୍ଟ କଣ ଚିଠିଟା ହ୍ୟାଣ୍ଡ ରାଇଟିଂ ଏକ୍ସପର୍ଟ ଇଏ ହବ ତାପରେ ଆଡମିଟେଡ ହ୍ୟାଣ୍ଡ ରାଇଟିଂ ସେଇଥିପାଇଁ ନେଇଥିଲେ। ସୋ ଇଟ୍ ସୁଡ୍ ହାଭ୍ ବିନ୍ ପ୍ରୁଭଡ ଆଣ୍ଡ ଟ୍ରାଏଲ କୋର୍ଟରେ ମଧ୍ୟ ସିଏ ଆଇଡେଣ୍ଟିଫାଇ କରିଥାନ୍ତା ଯେ ଦିସ୍ ଇଜ ଦି ହ୍ୟାଣ୍ଡ ରାଇଟିଂ ଇନ୍ ଦି ହ୍ୟାଣ୍ଡ ରାଇଟିଂ ଅଫ ମାଇ ଡଟର। ତେଣୁ ତାହେଲେ ଇଏ ହେଇଥାନ୍ତା। ତେଣୁ ସେ ଚିଠିରେ କଣ ଲେଖା ଅଛି ନା ପିକ୍ଚର ଅଛି ଖାଲି କହୁଛି ଚିଠିରେ ଗୋଟେ। ଆଚ୍ଛା ତାପରେ କଣ କହିଲା?
ତାପରେ କହିଲା after receipt of the letter I went to the house of accused person along with Sudhanshu.
ଆପଣ କୋଉ ପାରାଗ୍ରାଫ ଟା ପଢୁଛନ୍ତି?
ତାପର ପାରାଗ୍ରାଫ 7
ଆଚ୍ଛା ହଁ ପଢନ୍ତୁ।
Reached at 8 p.m. when my daughter started crying seeing us. Accused Kotti and Sunni pushed her inside a room and closed the door. When Sudhanshu Giri inquired from the Lakshmipriya as to the reason for the dispute, she told that the accused person were demanding gold ornaments and she was being ill-treated for non-giving of the same. Lakshmipriya further complained that she was not being given food to eat and was being assaulted by accused Sunni and Kotti. She further told that the accused Prahalada was also assaulting her. Accused Govinda impressed upon me to settle the family matter and accordingly we returned to our house. On 20/4/2000 at about 8 p.m. my daughter made a telephonic call to me. We came to the house of the accused person about 9 p.m. On that day I found no vermilion mark on the forehead of my daughter and bangles of Sankha were also not in her hand. My daughter cried holding my hand. Wife of accused Govinda took Lakshmipriya to the house. When I gave proposal to take away Lakshmipriya to my house, accused Parameswara and Govinda impressed upon me not to do that as it was their family affairs. At the time of our departure, when Lakshmipriya wanted to see us, accused Kotti gave a push to Lakshmipriya and put her inside the room, and accused Kotti at that time said that Katha Kohile Saribo Nahi. Accused Parameswara and Govinda gave assured to me to bring Lakshmipriya to my house with her husband on the next day after specifying the situation.
ଏଇ ଯୋଉଟା oral evidence ରେ ଆସୁଛି ମାନେ what you are telling that about torture part କିନ୍ତୁ victim ର dying declaration ରୁ ସେଇ ଯୋଉ particular line ଟା ଆସିଲା ଯେ none had told with regard to dowry articles except scolding her. ତେଣୁ ଡାଉରୀ କଥା କେହି କହୁନଥିଲେ, ଖାଲି ଗାଳି ଦଉଥିଲେ ଆଉ ଗାଳି ବି 2 ଜଣ ଦଉଥିଲେ ସେ ସ୍ତ୍ରୀ ଲୋକ। Another thing you just see that it depends upon temperament of a person. ତ କୋଉ କାରଣ ପାଇଁ ଗାଳି ଦେଇଛନ୍ତି ଯୌତୁକ ପାଇଁ ନୁହେଁ, ବାକି କୋଉ କାରଣ ପାଇଁ ସେଟା ପିକ୍ଚର ମାନେ ସାମ୍ନାକୁ ଆସୁନି ତା ଡାଇଂ ଡିକ୍ଲାରେସନ, ଖାଲି କହୁଛି ଯେ ମତେ ସକାଳୁ ଗାଳି ଦଉଥିଲେ। ତେଣୁ ଏଇ ଯଦି କୌଣସି ଧର ଘରୋଇ କାରଣ ପାଇଁ ହେଇପାରେ ବା କଣ ହେଇପାରେ, ସେ ଗାଳି ଦଉଥିଲେ ଏବଂ ତାକୁ ଜଣେ ଲେଡି ଯଦି ଏକ୍ସେପସନ ନେଇକିନି ଯଦି ସୁଇସାଇଡ करे born injury, can it be said that they have abated the commission of suicide? ସେଇଟାକୁ ମଧ୍ୟ ଆପଣ ଷ୍ଟଡି କରନ୍ତୁ ମିଷ୍ଟର। ଏଟା ଜଣେ ଗାଳି ଦେଲା ତ ଭେରିୟସ୍ ରିଜନ ପାଇଁ ହଉଛି କି ମାନେ କରନ୍ତୁ ଝିଅ ପରଫର୍ମ କଲାନି, ମୁଁ ଗୋଟେ ଏକ୍ସାମ୍ପଲ ଦଉଛି, ପରୀକ୍ଷାରେ ପରଫର୍ମ କଲାନି ବାପା ଗାଳି ଦେଲା, ଝିଅ ଯାଇ ସୁଇସାଇଡ କରିବ
କରୁଛନ୍ତି।
ହଁ ତ କ୍ୟାନ୍ ଇଟ୍ ବି ସେଡ୍ ଦ୍ୟାଟ୍ ଫାଦର abated the commission? ତେଣୁ डे टू डे फैमिली लाइफ रे धर क्वारल होउची एवं ताकू विभिन्न टेम्परामेंट की एक्सेप्शन नबो तेणु सेठी अनलेस से टाइप रो मटेरियल जदी न आसीबो how can you say that because it was of such a magnitude that must be evidence on record that it was of a such a magnitude
Yes,
that he
I got your
thought it
lordship
proper
point.
that I am to end my life.
Yes,
I have no way to escape. I am to just finish my life.
that is why in the decision of the Honorable Apex Court has stated that the abatement should be to the extent that you go and die, you have no right to live.
That is
That is
the
that decision.
they have used the words proximate link.
Yes, ma'am.
Proximate link थिबा दरकार.
Yes.
तो की गोटे कौन कही देला ताकू एक्सेप्शन नहीं कि नहीं
सुसाइड कर देला
होउची आजिकली तो होउची कि so can it be said the other person abated the commission? That also, in that light also you examine.
Yes.
But I find that whatever be material is there as per the dying declaration only against those two ladies, right?
So for others are concerned, they are rather they have stated that you just settle the dispute. They have no role so far as
the
Govinda
this
and Parameswar.
dying declaration was recorded on 21/4/2020.
Yes.
2000. And when she died actually?
26, man. 26 for
26.
26 for 2000.
Born injuries hela kebe 21 तारीख ना 20 तारीख इतला
22 तारीख
ना 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 22 है नहीं बड़ा 21 तारीख रे डाइंग डिक्लेरेशन रेकॉर्ड कर जे 22 कोन
21 तारीख रही 21/4/2000.
So the evidence of PW7 also indicate that on 21/4/2000 my uncle told me about sending information to him the ill treatment of Lakshmi Priya. I accompanied my uncle to the house of the accused persons. I did not find so and so. The body of the Lakshmi Priya accused came and in their presence told nature of ill treatment shown to her. When impressed the accused persons about her intention to take away Lakshmi Priya from their house, they assured us to settle the matter, as it's a misunderstanding among the family member. Lakshmi Priya told to come with us as she apprehended that he would be killed. Pati at that point of time put for mentioning gold ornaments. He would leave the Lakshmi Priya the next morning. After evening of the day, we got the information that Lakshmi. That means घटना ହେଇଛି 21 ତାରିଖ 21 ତାରିଖ ନ ଏମାନେ କହୁଛନ୍ତି ଆମେ ସକାଳୁ ଯାଇଥିଲୁ ଏଇ ଟାଇପ ର ଗୋଟେ ଇଏ ହେଲା ସେମାନେ କହିଥିଲେ ଆମେ ସେଟଲ କରିବୁ ବୋଲି ଆଉ ନେଇକି ତାକୁ ତା ପରଦିନ ଛାଡି ଦେଇ ଆସିବୁ ବୋଲି ମଧ୍ୟ କହୁଛନ୍ତି paragraph 3 ରେ PW7 evidence that accused Pari told that he would leave Lakshmi Priya in our house on the next day morning after supplying bangles and putting vermilion on her forehead. So that is how it is stated. But another also, you also examine that marriage has taken place back 7-8 months.
Yes.
She was pregnant for 2 months. Why she would end her life unless she is hurt to that extent by maybe due to this overtact committed by these two ladies. तार स्टेटमेंट रु एमानक रेस्पॉन्सिबिलिटी आसुनी तेणु सेटा मध्य अवश्य मैग्नीट्यूड जोटा देखिया को हेले that is also another factor which is to be taken into account.
Now, why a married lady has been removed the vermilion and Shankha.
That is one,
Yes.
one thing. And why she would, when 2 months pregnant, is it
Yes.
there in the PM report that she was pregnant? That is, who is the doctor? PM doctor is?
PW6 one.
No, PW6 initially examined karthala. The doctor who conducted postmortem examination, I said. He was examining. Then PM report praman ହେଇଛି list of exhibitor ଦେଖିଲେ
No.
PM report
PM report ହେଇଛି
କେତେ number exhibit 16 बोले ना 10 exhibit 10. Let us come to exhibit 10.
Yes, madam.
Exhibit 10 टा की प्रमाण करेला देखिले This is 9. No, this is exhibit 9. Then this is exhibit 11. से बड़े लंबा कागज थी वो देखी बाहर कर लो PM report आ दियो असी स्कैन कॉपी देखो पोस्टमार्टम रिपोर्ट हाँ अरे खोजियो था दियो All right, I'm making it hard in part. We'll take up this matter next week.
Yes, ma'am.
Get prepared and prepare your note. And now, if we come to the this is an appeal of the year 2003. 20 years have passed. All these persons are surviving this 59.
They survived.
Huh?
But, in the meantime, both the appellant number 2 and 4, they have retired from service. Retired in means, my lord, they were put on the suspension.
No. Whether also take instruction whether all these 5 are surviving or not. Mr.
Yes.
Okay. Write the letter to that Baripada town IIC to obtain instruction. Okay. You received the paper book?
Yes. Yesterday I received that. Is all.
The London Council for the appellant submitted that yesterday he has received the paper book and he also placed the relevant parts of the judgment and also the evidence and seeks for an adjournment till next week. Place this matter on 20th of July 2023. Hard in part karibe. Hala?
Okay.
Okay, what is this item number 5?
May I please, Your Lordship, the brief facts of this appeal is that, Lordship, the appellant stood as surety in Komna police station CS case number 1 of 97, which corresponding to GR case number 21 by 97 for the offences punishable under section 147, 148, 323, 294, 149 of the Indian Penal Code, read with section 3 IX of the SC and ST Prevention and Atrocities Act.
Then what happened?
Then, Your Lordship, on dated 1/2/1997, the appellant, who is the surety, he filed an advance petition through his counsel stating that when he is going to the village of the accused persons to take him to the police station for his appearance, at that time they are absent in their village and they are linked up with another case, and they are absent in their village, for which he filed an advance petition to release him from from his responsibilities.
Yes.
Then he filed a show cause notice by annexure.
So cause notice must have been issued. Intimation must have been given to the accused to engage some other surety.
Lordship, then the petitioner filed a show cause notice on 21/2003.
Which order you are challenging?
We are challenging, Lordship, the order dated 18/9/2003 by Annexure 5.
Please place it.
In this order, Your Lordship, I am just reading out. Record is put off today. No step is taken either by the delinquent or by his advocate. The delinquent had filed his show cause on 21/2003. The delinquent was the surety for the accused persons, namely Lalit Das, Sanjeev Panda, Devaraj Sabar, and Indramani Panigrahi in GR case number 21/97. Even though the delinquent had filed his show cause, but he is not appearing in the court for which his show cause cannot be considered. The bail bond had already been forfeited on 1/2/1997. Hence, penalty of rupees 20,000 is imposed. Draw fine check, issue DWA along with conditional NBWA against the delinquent to the PS Bhavani Patna and put off on 27/10/2003, awaiting execution of NBWA and DWA.
So what happened then?
Lordship, we have agreed by this order.
No. Ultimately, what happened to these accused persons in that trial?
Accused persons, Your Lordship, they have acquitted from.
Where is their judgment?
Lordship, in the show cause, if annexure 4 in the show cause, Lordship, there is averments.
Annexure 4.
Yes, Your Lordship.
Annexure 4 is the true copy of the.
Sorry, Annexure 3, Your Lordship.
Annexure 3.
Yes, Your Lordship.
Okay, read it.
Lordship, in paragraph 2, that however, in the meantime, all the co-accused persons have been appeared and the trial court of the case has already been concluded, in which the accused persons have already been acquitted from the charge labeled against them on dated 30/4/2002.
Yes, Mr. Apatro. Here, the accused persons have been acquitted. He was a surety.
He's the bailer. He's the bailer.
Right. Accused persons appear Kornathan say this criminal appeal has been filed by appellant Pradeep Kumar Das under section 446 of the CRPC, challenging the impugned order dated 18/9/2003, passed by the learned additional session judge Kamanwapada in CMC number 1 of 1997. It appears that the appellant stood as surety for the accused persons in Kumna PS case number 1 of 1997, which corresponds to GR case number 21 of 1997 in the court of learned SDGM Nuapada, in which the accused persons were charge sheeted under section 147, 148, 323, 294, 149 of the Indian Penal Code, reduced section 3(1)(x) of the SC and ST Prevention of Atrocities Act. The four accused persons, namely Indramani Panigrahi, Sanjeev Panda, Lalit Das, and Dweja Sabar, were released on bail as per the order of the Land and Special Judge Kalahandi Noapada at Bhavani Patna by the order dated 27/1/1997 with certain conditions. And one of such conditions is that they will appear before the investigating officer at Komna police station on every Saturday at 10 a.m. And the appellant, as a surety, furnished bail bond on 1/2/1997. The appellant filed an advance petition through his counsel, stating therein that he might be discharged as surety and appropriate order may be passed in that respect. And it has been stated in the petition that he had gone to the village of the accused persons to produce them at Komna police station on Saturday on 1/2/1997, but could not find them in their respective houses. And on an inquiry, would come to know that they have been entangled in another case, for which they are not going to attend the police station. The Land Special Judge, on receipt of the application, and hearing the counsel for the appellant, rejected the petition and issued non-bailable warrant of arrest against the accused persons for their production on the date fixed. The Land and Special Judge also directed to start a separate miscase against the appellant. Stop. As per the direction of the Land and Special Judge, criminal miscase number 1 of 1997 was initiated, and the appellant was noticed to file his show cause as to why the amount shall not be recovered, shall not be forfeited. The appellant, on receipt of the notice, filed his show cause. And stated his bona fideness in bringing to the notice of the court the conduct of the accused persons in disobeying the order of disobeying the bail order, and to discharge him as the surety. It was also brought to the notice that since the accused persons have been acquitted from the charge leveled against them by judgment and order dated 34/2002 it should not be imposed with any fine. However, the learned additional session judge cum special judge by the order dated 18/9/2003 passed the order imposing penalty of rupees 20,000 and also issued DWA along with conditional non-bailable warrant of arrest against the appellant. What is your good name?
Abhishek Pradhan, Your Lordship.
Mr. Abhishek Pradhan, Land Counsel, appearing for the appellant, submitted that the forfeiture of bail bond without giving any opportunity to the appellant to have his say is illegal and it is against principle of natural justice. The Land Counsel further submits that when the appellant himself brought to the notice of the court about the conduct of the accused persons and made a prayer for discharge, expressed his unwillingness to continue as surety for the accused persons. The learned trial court should have noticed the accused persons for giving any fresh surety. And the forfeiture of bail bond is illegal and the impugned order cannot be sustained in the eye of law. Have you brought that decision?
Lordship, I have just citation number, but didn't brought.
This ground which has been taken, that is supported by many a decision. Forfeiture of bail bond without the notice to that is illegal and it cannot be sustained in the eye of law. The forfeiture of bail bond without notice to the surety is illegal. The Learned Counsel for the state is supported the impugned order. Considering the submission made by the Land Counsel for the respective parties, since the forfeiture of the bail bond without giving opportunity to the appellant to have his say is illegal and suffers from principle of natural justice, and in view of the bona fideness of the petitioner in bringing to the notice of the court regarding against the conduct of the accused persons in flouting the terms and condition of the bail bond, and without asking the accused persons to give fresh surety, the action taken against the appellant, particularly imposition of penalty amount of rupees 20,000 and issuance of DWA and conditional NBWA cannot be sustained in the eye of law, which is accordingly set aside. That would add one more particularly when the accused persons have already been acquitted after facing trial, this order cannot be sustained in the eye of law. Criminal appeal is accordingly allowed. Yes.
Item 6.
No, it's item 1.
Item 1.
Yes. Please come to this side. Mic, adjust your mic.
My lord.
Yes.
Appellant with another person faced the trial in SP case number so and so 143 of 94 in the Court of Special CGM CBI Bhubaneswar. The trial court
This matter was last listed on 22/3/23.
My lord.
Your Lordship, if your Lordship,
On that day, my lord directed to produce some original records from the trial court. That was
Right.
the order.
Okay. So it's a case of conviction.
Yes, my lord.
Initially, in which court you were facing trial?
My lord, in the CBI court, my lord, CGM.
Okay.
Bhubaneswar.
That is additional CGM come special CGM. Then you face trial under 120B, 420, 468 and
471.
71. And you were convicted on all these offenses or acquitted?
No, all these offenses.
Okay.
Conviction under 120B, 420 and 463. All convictions.
Okay, you just read the paragraph number 2. Let me know because it is such a long gap. Is paragraph 2 of the trial court judgment. Yes.
Yes. From paragraph
2 of the trial court judgment.
On the basis of source of information, this case was registered on 8/2/94 by the FIR Exhibit 56. Originally, the FIR was registered against the accused Rudanand Sethi, postal assistant, and one Kartik Chandra Mahanti, authorized postal agent of Jajpur Road Railway Station, Post Office, on the allegation that They conspired with each other to commit criminal conspiracy, and in pursuance of the said conspiracy, the first signature of depositors and withdraw money from their account and cheated the postal department. During investigation, the IOPW 9 sees several documents. Investigation reveals that the accused Radhanand Sethi, the postal assistant, and Achyutananda Panda, head clerk of Jajpur Road Railway Station post office, entered into an agreement to commit criminal conspiracy, and in pursuance to the said criminal conspiracy, first the signatures of the depositors Arjun Sethi PW1, Gangadhar Naik PW4, Ramakant Sahu PW3, and Janaki Vallabhpradhan PW2, and prepared false documents, withdrawal forms, and withdraw amounts from their saving bank accounts number so and so, for accounts number respectively, by using the said false documents as genuine ones, and cheated the postal department. On termination of the investigation, charge sheet was placed against the accused Radhanand Sethi and Achyuta Panda to stand their trials in the court of law under section 120B, 420, 467, 468, 471 IPC, and subsequently charges was framed against the under offences as referred above, save and accept offence under section 467 of IPC, hence the case.
So it appears that two of the accused persons face trial.
Yes, madam.
Now, both of them have been found guilty.
Yes, madam. Two appeal is in my lord's board. I am appearing in first case.
Okay, you are appearing in Hudananda Sethi's case. Okay.
Madam.
So they were found guilty, and what is the punishment? Which paragraph it deals with that? The operative part of the judgment.
Yes, ma'am.
The sentence, what sentence has been imposed?
This is paragraph 21 last page.
21, okay.
Internal page 15.
Just.
On thorough scrutiny and scanning of the evidence on records and facts and circumstances of the case, I am of the opinion that both the accused persons made an agreement to commit criminal conspiracy, and in pursuance to said criminal conspiracy, they forced the signature PW1 and 4 in 1 to 4 in the withdrawal slip, and manufacture false documents, and on basis of said false documents, they withdraw money to the tune of 22,000 from the accounts of PW1 to 4, and cheated the postal departments to the tune of the said amount intentionally, and for the purpose of cheating, they dishonestly and fraudulently utilized the forced withdrawal slips as genuine documents. The defense has not been able to impeach the veracity of prosecution witness to discard the brush aside their evidence. Rather, the evidence of prosecution witness stands as on assault and unimpeachable. Prosecution has proved all the charges against both the accused persons beyond shadow of all reasonable doubts. Accordingly, I hold both the accused persons guilty under section 120B, 420, 416, 471 IPC.
Okay. So then the sentence part is in the next page. And for each of the offense, you are directed to be sentenced for RI for 3 years and fine of rupees 3,000 in default to undergo further RI for 6 months.
6 months each, and count further each of the sentence undergo RI for 1 year.
1 year for this 471, other 3 it is 3 years and concurrently. So it is 3 years. Now what the appellate court did, they dismissed the
dismissed and confirmed the
total, no sentence also, sentence also remain changed, same. Okay. Both of you preferred separate appeals, right?
Yes, ma'am.
So now it appears that the accusation is that from the account of 4 persons who have been examined as 1, 2, 3, 4, a sum of rupees 22,000 alleged to have been misappropriated.
Yes, ma'am.
So let us come to the charge first, and then we'll go trial court record dio. Charge ta bar karon. So charge is during the period from 14/6/93 to 20/10/93 at Jajpur Road Railway Station Post Office caused to be done an illegal act withdrawing 8,500 from Arjun Setila PW1. RL 8,500, okay. Then 5,000 from the account of Gangadhar Naik, PW4, rupees 5,000. Then 2,500 from the account of S.K.SAHOO, মানে Ramakanta Sahu, PW3. That is 2,500. Then 6,000 from the account of Anaki Balhav Pradhan. So it is PW2, that is rupees 6,000. That means 0. Okay. 5, 5. Take no, 915, 17, 5, 22. Okay. Rupees 22,000. Okay. Let us come to the evidence of PW1.
Ma'am.
Because prosecution case is that you have withdrawn a sum of rupees 8,500 from his account and creating certain documents, forging the signature. Let us see. Read.
But I have the appellant has not made that signature.
No, just please. I am.
Yes. Ma'am. From 1986, PW1 Arjun Shetty.
Yes.
From 1986 to 1993, I was working in the office of the Orissa Lift Irrigation Corporation, Jarka. I had one SB accounts in Jajpur Road Railway Station Post Office, and I was issued with one passbook. I was personally operating the said account at the time of deposit. I was handed over the cash along with the deposit slips to accused Shudanand Sethi, who was sitting in the counter. At the time of withdrawal also, I was handing over the withdrawal slip to accused Shudanand on 8/6/93. I approached the accused Shudanand for withdrawal of amount of rupees from my SB account, but he stated that my account has been made silent and the same has to be made up to date only after deposit of the passbook with him, which will be sent to the Jajpur head post office. As per the direction of the accused Hudanand, I hand over my passbook to him, and in token of receipt of the passbook, he granted me one receipt. Exhibit 1 is that receipt, and the accused Hudanand made an entry regarding the balance of my account, that is 9,928. It is a 7 paisa. Exhibit 1 was filled in my presence by accused Hudanand. About 1 month thereafter, I approached the accused Hudanand about my passbook, but he replied in saying that the passbook has not been received back. In this way, I approached the accused Hudanand for my said passbook for the last time in the month of December 93. I approached accused Hudanand for my passbook, but he failed to return. So I went to Jajpur head post office and approached Sujyamani Mahanti Assistant Postmaster and reported the same to him on 15/3/94. I reported the matters to Assistant Postal Superintendent in writing. Exhibit 2 is my application. At the time of opening my account in the said post office, my specimen signatures were often in the said post office. Exhibit 3 is the sheet containing my specimen signatures. On 3/5/89, I had deposited ₹20 in my SP account on number so and so. Exhibit 4 is the said deposit slip, and Exhibit 4/1 is my signature. I have never withdrawn 8,500 on 20/10/93 out of my SP account through messenger Pramod Kumar Shetty. The signature appearing in the withdrawal slip marked as X is not my signature. The withdrawal slip is marked as Exhibit 5. There are regarding the withdrawal of 8500 by the Postal Authority, and during such inquiry, my statement was recorded as Exhibit 646 in my statement, and Exhibit 6/1 is my signature. During such inquiry, the Postal Authority obtained my specimen signature in one sheet. Exhibit 7 is that sheet containing my specimen signatures cross-examination by the defense. One Mr. Shatpathy has recorded my statement under Exhibit 6. Shatpathy is my lord, departmental inquiry official. During inquiry, I do not remember the exact date of recording my statement under Exhibit 6 while recording Exhibit 6. No other witness was present. While I hand over passbook to the accused Rudanand, I sign in form given by him. It is a fact that I did not state before the IO that whenever I used to deposit, I hand over the money along with the passbook to the accused Rudanand, and at the time of withdrawal, I also hand over the withdrawal from form to him. The question under Exhibit 6 were prepared by Mr. Satpathy at the right side top corner of page 1 of Exhibit 6. It was first written as Arjun Chandra Sethi but by Mr. Shatpathy, but he has scored through the word Chandra, but he has not put his initial against it. It is not a fact that by submitting withdrawal slip, I have received 8,500 out of my SP account. Though my messenger through my messenger Pramod Kumar Sethi, it is not a fact that I have received 8,500 out of my SP account. I have falsely lodged complaint. Corrected by me.
So this particular, when he gave the passbook in paragraph 1 or so and so, at the time of withdrawal, I was handing over the withdrawal slip. On 8/6/93, I approached for withdrawal of money from my passbook, but he stated that my account has been okay. The same was to hand over date only after deposit passbook with him, which will be sent to Jajpur. Okay. As for the direction of the accused, I handed over the passbook to him in token of receipt to the passbook, so and so. Okay.
You are giving complaint regarding the not issuing of passbook, not return of passbook.
The amount that was available at that point of time was 9,928. Then he says, when I ultimately got it, it was found that on 20/10/1993, 20/10/93 months, almost 4 months and some days after the handing over the passbook, 8,500 has been withdrawn from the account through on messenger Pramod Kumar Sethi. The signature appearing with the withdrawal slip marked as one so, and with withdrawal slip is marked there on कौन है? Okay. कौन सी? हाँ ଏତେ ସମୟ ଚାଲିଲା ପରେ କଣ ବନ୍ଦ କରୁଛି? ହୁଁ What is the post this man was holding? Rudananda and Achyutananda?
The postal assistant. He is postal assistant, and Achyutananda is the senior to this person.
Achyutananda is postmaster, my lord.
Hmm?
Achyutananda Panda is postmaster, my lord.
Rudanand.
So he was the head clerk.
Where from you got it?
Lordships may come to the paragraph 2 of the judgment.
Of the trial court?
Trial court, it says that investigation revealed that accused Rudanand Sethi, postal assistant, and
Rudanand Sethi is a postal assistant.
And Achyuta Panda is the head clerk of Jajpur railway station sub post office. It is in paragraph 2, Lordships.
Achyutananda Panda. Achyutananda Panda court ଲେଖା ହେଇଛି?
Paragraph 2, they forged signatures of depositors and withdraw money from their account and cheated the postal department. During investigation such and such, that accused Rudanand Sethi, the postal assistant, and Achyuta Panda, head clerk of Jajpur railway station, sub post office entered into an agreement. It is in paragraph 2, your lordships. 7th line.
Of the trial court judgment?
Lordships of the judgment dated 19/2/2022.
Oh, 19 to 20. No. I'm holding the...
It is the magistrate judgment.
Chief Judicial Magistrate.
Yes.
Additional Chief Judicial Magistrate comes Special CJM.
Yes, your
That
lordships.
judgment is dated 5/3/2002.
Yes, your lordships.
No, but in that very paragraph number 2, it is mentioned that one Karthik name is mentioned.
Page 2, my lord. It is on 1, 2, 3, 4, from 4 lines. During investigation on the IO9 seizes several documents. Investigation reveals that accused Rudanand Sethi, the postal assistant, and Achyuta Panda, head clerk of Jajpur Road Railway Station, sub post office, enter into an agreement of common conspiracy.
Paragraph number 2.
Yes, my lord. Paragraph number 2, page 2 of the trial court judgment, my lord. 1, 2, 3, 4, 5, 6, 7. On 7 line, last question. 7th line, my lord. Achyuta Panda, head clerk. Judgment dated 5/3/2002. Page 2. 7th line, my lord. The postal assistant and
second page ta pade gala. ये ट्रायल कोर्ट जजमेंट एटा 1 पर 3 अछि सेपे मु खोजुची दुईटा पड़ाला कौन 3 4 5 7 9 एमती जी देखिए पेज 2 रो जो ये कहीं डका की कहीं एमती से कर जी जजमेंट ए टाइप रो ये सब विषय बुझु छी ये बुझु छी हां के स्कैन कर जी What about the other one? This 21 ने ठीक है से ये देखिल ताको ये जो आरटा अच्युतानंद पंडा ये देखिए give it that file give that file to me. You see this one come here एक परे ता पेपर पढ़ाई जाइछि 2 4 अलगा जगह सब रही तेणु एटी 1 3 5 7 9 2 हरिका सब अलगा रही देख पड़छ तो से आकु डका से स्कैनिंग रो जे मेन ग्रुप अछि तो डका immediately go register डके आकु डाक टिको आसीबो yes so if the evidence of pw1 sorry that evidence trial court report. Evidence of PW1 is taken into account, then when he handed over the passbook to you, the amount available in that was rupees 9,000 some odd.
1,920.
Now that passbook has been marked as in Exhibit 1. Exhibit 1.
Exhibit 1 is the receipt, my lord.
Exhibit 1 was filled in my presence by the accused so.
Exhibit 1 is the receipt which when the PW1 submitted the passbook, Exhibit 1 receipt has been given to him, that has been filled up by him, and Exhibit 1 is the receipt.
No, what is the
That is
concerned passbook?
the concerned passbook on the last occasion, my lord, is directed to the concerned passbook is not in the LCR, my lord.
Then how it is to be ascertained whether that particular amount has been withdrawn or not?
Yes, my lord. And he has also lodged the complaint regarding the passbook, my lord, not regarding the withdrawal amount.
No. How the prosecution has stated that he said that I have never withdrawn an amount of rupees 8,500 on 20/10/1993.
Yes, ma'am.
So where is the material that on 20/10/93 that particular amount was withdrawn from your account? So what is the documentary proof in that respect?
The document has been exhibit, my lord.
What is the exhibit number?
Exhibit 5, my lord. It is written in, my lord, paragraph 2 of the deposition. I have never withdrawn amount 8,500 on 20/10/93 out of my SB account from messenger Pramod Kumar Sethi. The signature appearing in the withdrawal slip marked as X is not my signature, and the withdrawal slip is marked as Exhibit 5. There was inquiry regarding the withdrawal of 8,500 by the postal authority.
So let us say that in the withdrawal slip it is mentioned.
Yes.
But that means that is not mentioned in the passbook, right?
Passbook is not.
Passbook is not there. Then the corresponding postal documents, register, etc., must be there.
Yes.
To show that this amount has been withdrawn 8,500.
Yes.
So what is that exhibit?
That is in the ledger.
Ledger kete number mark कीजिए. We are focusing only first one on PW1's evidence. What is the exhibit list? List of exhibits. नहीं से document उड़ा पड़ा वाला. देखिए. That is the entire file. It has come. Give it.
Lordship, may kindly have a look at Exhibit 36. That is the ledger.
Official Delhi account, Exhibit 42 to 47.
Just so have you verified this? What is his passbook? Passbook has not been proved in this case.
No, passbook has not been proved.
Last date of hearing also, Your Lordship, was.
Okay, then suppose you are trying to prove it by way of withdrawal slip entry and the entry that is made in that register.
Yes.
So withdrawal slip has been marked as what is that exhibit?
My lord, in exhibit 36 to 40, daily list of transaction dated 14/6/93.
No, ये जो PW1 से कहला नहीं एटा ये withdrawal slip टा
Yes, that exhibit is exhibit 5.
5. 1, 2, 3. Okay. এটা হচ্ছে withdrawal slip. ये document पढ़ा लो. Exhibit 5 अच्छा. ଆଉ ଗୋଟେ କୋଉଟା କହୁଥିଲେ ଆଉ କୋଉ document?
Exhibit is the complaint, but that is also not in.
No, exhibit 5 is the withdrawal slip.
Yes, sir.
Which indicates that on 20/10/93,
Yes.
sum of rupees 8,500 that was withdrawn. And after it is mentioned that after withdrawal, the balance is rupees 4,476. And
Your Lordships, exhibit 5 is the withdrawal. Exhibit 5.1 and 5.2 are the signature of the accused, which is proved by BW8.
that is correct. But this must be there must be a corresponding. This is the withdrawal slip, but basing on that, the entry must have been made in the concerned register.
That ledger, that ledger is exhibit 40, 36 to starts.
30?
The list of transaction, Your Lordships, is exhibit 40. Which relates to the date of withdrawal, 2010.
Just a minute. Come here, come. The item number 1 hearing. Okay. This file is criminal revision number 17 of 2003. Okay. So he has filed the judgment. And the judgment is this. এটি বাহার করে সেটা ইয়ে এটি রেকর্ডটা হওয়া কিন্তু সেই যে সেকেন্ড রিভিশনটা কোটা you see ସେମାନେ ଠିକ ସେ ଦେଲେ ଏଟା ହଉଛି ସେଇ SP ର 43 of 94 ର ଏଟା ଜଜମେଣ୍ଟ ହେଲା ସ୍କାନିଂ ରେ ହେଲା ଏଟା ଫାର୍ଷ୍ଟ পেজ ତାପରେ ଉଲ୍ଟାନ୍ତୁ ଆପଣ ଏଟା କେତେ ଅଛି পেজ ନମ୍ବର 2 you see it come page number 3 then ଉଲ୍ଟାନ୍ତୁ 4 ଅଛି ସ୍କାନିଂ ହେଲା पेज नंबर 5 तो 1 पर 3 3 पर 5 5 पर 7 7 पर 9 बुझी पर्यंत सो नाउ कौन हेची ना जो अलगा करिसेंती से तापर कौन करिसेंती सेई टाइप सब गुडा को गोटे गोटे नंबर छाडी 13 पर 15 17 हैला ए जजमेंट सरी गला परे से टोटाल कुआडे गला से जो बाकी तक अर्थात 2 सेगुड़ाक कोठी माने जना पड़ुनी ଆପଣ ତ ଦେଖିବେ ଓରିଜିନାଲ ଜଜମେଣ୍ଟ ଏଇଠି ଅଛି ତ ओरिजिनल जजमेंट कौन अच्छी मु तो जजमेंट देखा ना ये देखो इन दि कोर्ट ऑफ जजमेंट नुहे भिकारी चरण राव ये देखो है एडिशनल सीजीएम नंबर पड़ी डेट ऑफ जजमेंट होची 5/3/2002 रो देखुछन का दिरे एटा ताले एटा कोठ आसला से क्रिमिनल डिवीजन नंबर 17 एटा 17 फाइल नुहे एटा हाँ रुहतु बस 21 फाइल भी लेट अस से 21 फाइल टा पड़ाला okay this one is 21 file hold it देखो 21 नो ट्रायल कोर्ट जजमेंट बात एटा होची 21 वर्तमान आसिला सेगुड़ा कोठ आसिला से एमसी कौन से देइछ এই জিনিস সে কোড পাইলা এটা তো 21 ফাইলটা না এখন এটা 21 ফাইলটা করছি sure. अरे वो ऊपर तुम स्लीप मारुचंदी थोड़ा जेरोस करू ना एटा हाँ अच्छा एलसीआर भी तो आउरी माने ये थी वो ना एलसीआर भी एटा एलसीआर ता कोड का पाइलो तो एक मुड़गन एटा एलसीआर तो कोड अच्छा ठीक है एलसीआर बार एलसीआर इज हियर आगुरा आस्तला
Exhibit 36 is the ledger entry and Exhibit 40 is the daily transaction list. Exhibit 40, your lordships, also indicates
yes,
the date of.
I got it. Exhibit 40, I got it. Yes. Exhibit 40 day.
Exhibit 40 also speaks about the date of the withdrawal, that is 2010-1993, your lordships.
We hand over this exit code is ସେଟା ମୁଁ ଏଟା ତ ଖାଲି ପାସବୁକ୍ ଗୁଡାକ ମେନସନ ହେଇଛି यार पासबुक नंबर केम जानियो आर अकाउंट नंबर PW1 ର अकाउंट नंबर केते गोटिए मात्र 8500 withdrawal ହେଇଛି but
Account number, your lordship, is 132441. That account number, lordship.
that is withdrawn ଲେଖା ହେଇଛି ମଧ୍ୟ amount of withdrawal ଲେଖା ହେଇଛି ସେଟା
So that amount which is withdrawal is proved in that exhibit 36, because exhibit 36(1) is the entry, your lordships. If your lordship will go to the ledger, with that ledger 8500 should have been reflected, because there is an entry. That entry is 36(1). If there is an entry, your lordship, the amount might have been reflected in exhibit 36.
other ଲେଖା ହେଇନି other entry there is no entry of 8500 in this exhibit 36
but 36(1) is the relevant entry, your lordships. Lordships will.
yes
36(1) it may be there, lordships.
okay yes argue your case Mrs. Panda.
Yes.
Lord, I want to draw Manda's attention to the evidence of 8 manner PW8 who has made the departmental inquiry upon which evidence the trial court in paragraph 8 manner
PW8
yes PW Satyavrata Satpathy. I was working as assistant superintendent of post office Cuttack North Division, Cuttack from February 91 to May 1995. Jaspur Railway Station shop post office was under my administrative jurisdiction. At that time, Achyutananda Panda was working as a supervisor of saving bank branch of Jaspur Road shop post office. I knew Hrudanand Sethi and Achyutananda Panda and Sri K.C. Mohanty at the time. They were working as postal assistant of Jaspur Road sub post office, head clerk supervisor of sub SB branch Jaspur Road sub post office, and authorized saving bank agent of Jaspur Road sub post office respectively. As directed by the superintendent of post office Cuttack North Division, Cuttack, I conducted an inquiry into the allegation made by some depositors of saving bank and RD accounts at Jaspur Road sub post office. As codified in the postal manual, the procedure for withdrawal from SP and RD accounts is that the depositor should submit the application form for withdrawal along with the passbook at post office counter. The concerned saving bank post assistant should scrutinize the application form, examine the specimen signature of the depositors in the application form, and compare the same with the signature in the specimen signature book, and on satisfactory certification of specimen signature, he will allow the withdrawal. In fact, he should make necessary entry in the applications for withdrawal and also make necessary entry in the concerned SV or RD passbook, authenticate the entry by putting his initial date stamp of or the concerned office, and return the passbook to the depositor with the required amount of withdrawal. Thereafter, he will prepare a list of transactions made by him during the entire day and submit all the applications for withdrawal and pay in slips in the head post office along with the daily account and list of transactions. The postal assistant should also make the amounts of withdrawal in the sub post office long book and sub post office ledger to confirm the entry of the amount and withdrawal in the appropriate records. In this way, a withdrawal is allowed. In some cases, withdrawal is allowed in respect of saving bank account and RD account through messengers. The present case is also the Pramod Kumar Sethi is also messenger's method. He has filled up the form. The appellant has not manipulated any signatures or only things that he has not properly scrutinized that form, that withdrawal form, my lord. But messenger service is not allowed in respect of final withdrawal from the RD accounts. And this PWS once it is not final withdrawal, it is part withdrawal. The procedure is that the depositor should attest the signature of the messenger in the application side of the application for withdrawal. The postal assistant who deals with the withdrawal should verify the specimen signature of the depositor in the application form withdrawal, and if he is satisfied with the genuineness of the messenger, he may allow withdrawal to the messenger. When an unknown person comes to the post office being deputed as messenger or by the depositor, the genuineness of the messenger should be verified by the postal assistant before allowing withdrawal. In my presence, seizure lists were prepared by the CBI people, and Exhibit 25 to 28 are the said seizure list, and Exhibit 25.1 and 28.1 are my signatures. So also the specimen signatures of Rudan Sethi were often in my presence and by the CBI inspector. 5 seats might exhibit so and so. Right. On 14/6/1993, Sri Gangadhar Nayak depositors of the RD account number so and so had not submitted any withdrawal form to the post office for taking loan from his RB account. Exhibit 30 is the withdrawal form used for the purpose of same withdrawal by persons other than Sri Gangadhar Nayak, the depositor, and this payment was allowed by Udanand Sethi and Sri Achyutananda Panda, both the accused who had put their signature on Exhibit 30, and I am acquainted with their handwriting and signature, and Exhibit 31 and 32 are the signatures. But this OP number, this PW3, my lord, in his evidence has stated that I have not lost any amounts in his evidence, my lord.
No, Gangadhar Nayak is PW4, not PW3. This which
Yes,
you
ma'am.
read just
Yes.
that is
PW4,
PW4. Yes.
And I had examined the real depositors Gangadhar Nayak with reference to the said withdrawal and recorded his statement via Exhibit 21, wherein Exhibit 21/3 is my signature and Gangadhar Nayak also signed in my presence by Exhibit 21/1. I have recorded the statement in question answer form. I have often the signature of Gangadhar Nayak at the back side of Exhibit 30, which is Exhibit 30/3. His shared withdrawal has been reflected in the ledger of Gangadhar Nayak marked as 31, wherein the reflection is marked as Exhibit 31/1. Similarly, when Ramakanta
So you do one thing.
Yes, ma'am.
Since you are placing, you have already placed PW1's evidence.
Yes,
His name is Arjun Sethi.
Yes, ma'am.
So Arjun Sethi relevant paragraph is paragraph number 16.
Yes, ma'am.
So you come to that.
Yes, ma'am. Similarly, one Arjun Sethi had opened an saving bank account number 132441 at Jaspur Post Office, SP 28 SP 28 receipt by Exhibit 1 was granted to the depositor when the passbook concern was received from the depositor. Exhibit 3 is the specimen signature of Sri Arjun Shetty taken at the time of opening of the passbook. 17. On 2010-93, an amount of 8,500 has been withdrawn from SB account number 132441 standing in the name of Arjun Shetty. Exhibit 5 is the said withdrawal form.
35 is the withdrawal form. Exhibit 35 or 5 এটা? 30
Exhibit 5.
এটা 5 টা যে টিকে রো দেখে আউতো এটা কোন হলো এক্সিবিট 30 যেটা বাহার করছিল সেটা বাহার
আগে
না এই যে এক্সিবিট যেটা বাহার করছিল লিস্ট অফ এক্সিবিটস এক্সিবিট 5 টা বাহার করো Scroll down, scroll down. ये जो से तो बाहर को नथला डॉक्यूमेंट गुड़ा हाँ जे से डॉक्यूमेंट टा कहीं फिर लिस्ट ऑफ एग्जिबिट परे एग्जिबिट्स गुड़ा रहिवा कथा यस ये करो एविडेंस को से जो एविडेंस टा प्लेस करथिलो
para 17
वो एविडेंस प्लेस होला कारो
8 PW8
PW8
Satyavrat month
हाँ प्लेस करो
para 17
17
on 10/20/1093 an amount of 8,500 has been withdrawn from the SB account number 132441 standing in the name of Arjun Sethi. Exhibit 5 is the said withdrawal form. On inquiry, it is revealed that the amount of rupees 8,500 has not been taken payment by the depositor. It is also seen from Exhibit 5 that one Sri Arun Chandra Sethi has applied for the withdrawal, citing one Sri Pramod Kumar Sethi as the messenger, and Sri Pramod Kumar Sethi has put his signature in the withdrawal form. The withdrawal form has
अरुण कुमार सेठी की
और से एग्जिबिट 5 रे अरुण लिखा है कोनी आर जगह रे कोन सेटा करेक्शन है कि जे लिखा है
No, your lordship, there is a finding that both the signatures are different.
Exhibit 5
no the name of PW1 is
Arun name of his Arun Sethi Arjun Sethi Arjun Sethi that has been written as Arjun Chandra Sethi, and in that AR then J has been written corrected in that exhibit. It's like that.
Lordship, his name is Arjun Sethi, not Arun Chandra Sethi. So
Yes.
there it is Arun, not Arjun.
No, again that has been corrected.
that is corrected, but CH has been added.
Yes.
Number 2, the opinion is that this signature is not that of PW1.
Yes, ma'am. And it is also be that the messenger's name is also there, ma'am. Pramod Kumar Sethi.
No, what is your case? How you allow this for withdrawal? If because the requirement is that.
Yes, that is my point. But as the allegations is made, as the offense has been, that is not make out, madam. I may be not. I am eligible on the department because I have not scrutiny properly. But I have not. I have not. The appellant is not manipulate that signature, or he has not get any gains from that withdrawal, madam. And in para 32, this IO also the PW8 also stated that I could not know who had made entry that name in the withdrawal slip. In the same evidence, my lord, kindly have a glance to the paragraph 32.
Yes, sister.
Paragraph 32, my lord, on PW8. I could not ascertain who had signed in the withdrawal form in the name of account holder. I have not ascertained whether these handwritings and signatures in withdrawal forms belong to the accused persons or not. After inquiry, I came to the conclusion that the withdrawals were fraudulent ones. I have mentioned in my report Exhibit 53 that HN Sethi, N. Panda and S.K.SAHOO Mohanty committed fraud in respect of withdrawal of money. I have mentioned in my report at page 5 in para 2 that the previous conduct of A.N. Panda to verify and scrutinize the genuineness of the signature of the depositors on the withdrawal form with the specimen
What is the role of a postal assistant? You are a postal assistant.
Yes, I am a postal assistant.
What is the role? You the evidence is that you accepted that passbook.
Yes, ma'am.
And you said,
and I have given the receipt, ma'am.
Right, you have given the receipt, and you said that it will be
sent to head office.
It will be sent to head office.
Yes, ma'am.
And he didn't get it. Then complaint was made. And then it was found that even though he was an amount of rupees 9,000 and odd in his passbook when he handed over to you, but 8,500 was withdrawn on a particular date by utilizing one withdrawal slip. That in that withdrawal slip, neither this signature of this PW1 was there, nor it is not known that who is that messenger.
Yes, ma'am.
So in such a situation, how the withdrawal was made?
Yes, my lord, head clerk is to verify and scrutinize
That's why I'm asking you that what is the role of this Rudanand Sethi as postal assistant? Any evidence has come on record that what is the duty of the postal assistant? Suppose he receives the yes.
PW8 might have your lordships described about the role.
PW8 in paragraph 13 has stated how the transaction should be made, but it is not clear about the role of postal assistant, madam. In para 4, PW8 stated how the transaction should be made in the post office.
Because fact remains, Mr. Naik, he suppose the passbook he has received as a postal assistant, he received the passbook, and in good faith also, let us say he has handed over that receipt in token of receipt of the passbook, and he sent it to the head post office. So that much role is coming forth from the evidence of PW1. Then there is no evidence actually who filled up this exhibit 5, because you have not proved that the handwritings of available in exhibit 5 are that of the petitioner.
But you also this PW8 is acquainted with the handwriting of these two people.
No, they are acquainted with the signature, but he has not signed as Arun Sethi here. He has he has not signed here as Hrudananda Sethi. Suppose he is aware, he is acquainted with the handwriting of Hrudananda Sethi, signature of Hrudananda Sethi. So what he has stated, there is no signature of Hrudananda Sethi on that exhibit 5. Exhibit 5 indicates the signature of one Arun Sethi, Arun Chandra Sethi, or Arjun Chandra Sethi. So unless you take the specimen signature of that person, particular person PW1 ro, ଆପଣ PW1 ର specimen signatures ନେଇଥାନ୍ତେ, ତାକୁ କହିଥାନ୍ତେ ଏଇ ଟାଇପ ର ଲେଖ, 5-6ଟା 5ଟା ଖଣ୍ଡେ 10ଟା ଖଣ୍ଡେ ନେଇଥାନ୍ତେ, ଏବଂ accused କୁ ମଧ୍ୟ କହିଥାନ୍ତେ ଯେ ତମେ ଲେଖ, ତମେ ସିଗ୍ନେଚର ଟା ଦିଅ, ତମେ ରାଇଟିଂ ଲେଖ, ତାପରେ disputed ଆଉ admitted ଇଏଟାକୁ ଯାଇଥାନ୍ତା handwriting expert. Whether that has been done in this case?
No, my lord. In PW9 is the IO, my lord.
Yeah.
IO appointed by CBI. Kindly have a glance to his evidence, my lord. He has categorically stated that I don't fit. I am placing, my lord.
Which
PW9, my lord, Gopabandhu Patti. In paragraph 17, just I am
17.
Just as this query is going on, my lord, I am placing. It was para 17 of PW9.
He said that it was not necessary on my part to send the disputed writing to handwriting expert, Calcutta, for examination and opinion, since The same was already attended in the police. How you will prove the prosecution case then? Unless it is proved that this manipulation has been made by the appellant, by the petitioner, two petitioners, they have any role in that. The evidence is that he has just received the passbook, sent it to, that passbook has also not been proved. Question is that, what is your case that a withdrawal slip was created, and on the basis of that withdrawal slip, in the name of this PW1, 8,500 was withdrawn from his account, and it is mentioned that one messenger had come, as if one messenger had come and he was handed over the money. So that amount was ultimately withdrawn from his account. That is apparent. But question is that who has done it?
But on the last date of hearing, also this question came.
Yes.
Was of the first, your lordship was of the view that there is no doubt that your lordship's exhibit 5 is the withdrawal form.
Right.
Exhibit 5.1 and 5.2 are the signatures, and exhibit 36 is the amount which is reflected in the ledger. So, your lordship, there is no question that there is a forgery done and it was used to be genuine. 471 was made out. Lordship was prima facie of the view, because your lordship, there are judgments that
question is that you are right that unless if it is not that of the PW1, somebody else has done it, and by that process utilize that exhibit 5 to withdraw the amount of rupees 8,500 from the account of PW1. So obviously using a forged document as genuine, that has been done. So offense is made out. The second question is that who has done it? Is it, if it is not in the handwriting of, you have not proved that it is in the handwriting of this accused. So how you will establish a criminal charges against the petitioner? His role, whatever evidence has come, he has just received the passbook, sent it to the head office. Let us say that he has kept it, or it, because it was not proved, he has not sent it to the head office. Let us go to that extent. But that will not prove the prosecution case that he has committed the forgery or used the forged document as genuine. Because role of a unless you define what is the role of a postal assistant and what he has done in this particular case, either he himself has done it or at his instance somebody else has done it, and that is how there is some kind of conspiracy, and that resulted in the withdrawal of 8,500 from the account of PW1. So how you will prove it? Unless, first of all, handwriting expert opinion has not been taken. It was not sent for the handwriting expert. Now these are the just oral evidence asuchi. Semane depositors have said that we this is not our signature. It's all right that in the deposit slip these are not your signature. So one says that I handed over the passbook. From this, how can you establish these charges?
No, your lordships may kindly come to the magistrate's order. But the court was also of the view that there is a difference between the specimen signatures, and your lordship asked me to find out judgments that sometimes courts are expert of experts, and in that case, maybe section 45 of the Indian Evidence Act.
No, Mr. Nayak, let us accept that the signature which is appearing on the withdrawal slip is not that of PW1. Withdrawal slip है exhibit 5. এটা ଦେଖଉଛି ଯେ ଗୋଟେ କଣ ଅରୁଣ ସେଠୀ ନା କଣ ସେ ଯାହା ବି ହଉ is not that of PW1. So let us go a step further that PW1 has not signed the withdrawal slip, but from his account 8,500 has been withdrawn. But unless you further establish that it is the accused who has created this Exhibit 5, the withdrawal slip, which facilitated withdrawal of this amount. How can you fix responsibility on the accused? That is my question.
I got your point, your lordships. But your lordships, if your lordship will give me some time, I'll find out the role of the postal I'll find out that manual.
No, manual, unless you lead evidence, because it is to be adduced in the evidence, and he has to be given a chance of cross-examination also.
Yes, your
At this
lordship.
moment, you bring some book, that will not do. That
Lordship,
book, all those evidence are to be adduced before the by way of evidence, and he is to be given a chance to cross-examine.
Your lordship, I'll examine PW8's statement and also find PW8 statement, your lordship, PW8. Because he has done a question. There was a questionnaire of.
He has said that what is the procedure. Suppose somebody comes to withdraw money from his account, or somebody sends his authorized agent, let us say, to withdraw the money, or that word is used as messenger. So a person can himself go to the post office, fill off that form, and putting his signature, he can withdraw it. And what is the procedure? If someone is not able to go there because of some problem, health related problem or other problems, but he sends a messenger, then what he has to do? He has said that messenger signature, he has to uh, uh, that give authority, and he has to endorse that this is my, his signature also should be there also. So in that process, he has stated that that procedure is there. But I did not find anything that about the role of a postal assistant in that evidence.
Your lordships had asked a question on the last date of hearing, if your lordship will remember, that in this withdrawal form, your lordship, whether there is any signature of these two accused or not.
No, that is not there. That is not there. Exhibit 5, Exhibit 5, it is there.
Had it been there, directly 468 would have been made out. Your lordship was of the view.
Yes, there is nothing on this. Exhibit 5 is before me now, original. This Exhibit 5 and Exhibit 5 is one mark, it is there. And the other thing which has been marked on that Exhibit 5 is Exhibit 5/1. That is the signature of one Aruna Chandra Sethi, which has been corrected as Arjun Chandra Sethi. Obviously, the PW1's name is Arjun Sethi.
Yes,
He has never, is never signing as Arjun Chandra. Chandra word is not there. So on the plane also, if I see this signature which is appearing on the deposition sheet, and also this withdrawal form, it would be apparent that this is not his signature, because Sethi is completely different. CH is not there. Sri is something different. So this is not the signature of. So somebody has definitely prima facie forged it. This signature of Arjun Chandra Sethi. Question is that whether it is the accused who has done it. How you will fix that? Merely because proving a withdrawal slip and merely proving that from his account this amount has been withdrawn. Can you establish a charge against a postal assistant when there is no evidence that he has created that?
Name, place the para 33 of that PW8's evidence also.
30. Yes, please.
I have noted in my report that my predecessor K.S.H. Hota had inspected Jaspur Road post office. I have also noted in my report that my predecessor K.S.H. Hota had not reported anything adverse against H.N. Shachi and A.N. Panda. Exhibit 53 has not been submitted by me but submitted by A.N. Sahu, the then Superintendent of Post Office, Cuttack, North Division. The report which I submitted after conducting inquiry is not available in the case record. My submission is two IO has been appointed by the authority, by the department, and this person is the second person. And when the Casey Hutta has a inquiry, he has not found any guilt of the accused, my lord. And my humble submission before my lords that the signature, admittedly, the signatures differ from the original signature, but that has not written by me, man. That is so the.
No, you are not supposed to prove that that was not written by me. They are to prove that it was done by you. That is how they are to establish liability or prove the charge against you. They are to prove that it has been done by you, or at your instance somebody has done it.
But your lordship, even if they have not forged it, I'm trying to find out evidence that 468 is directly made out. Even if they have not forged it, also your lordship, 471 is made out because they have used it to be genuine, even if they themselves have not done it.
How you say that a postal assistant has utilized is genuine? He is not the man in charge of that maintenance of that account. What is that ledger? I'm telling you that if suppose he would have been in charge of maintaining that ledger, and from ledger shows that 8,500 has been withdrawn.
Yes.
That is supported by that withdrawal slip, right? Yes. But unless that man, this man, Hudananda, is in charge or he is entrusted with maintaining that ledger, particular ledger in question, then how can you establish that charge?
Yes.
I am a man who is sitting in the counter receiving the passbook, and he has given me the passbook. I said that take this slip, I'm sending it to make it update, and then you can utilize it. That much of role has been deposed to by your witness. Rest, there is nothing, neither any evidence, oral evidence, nor any documentary evidence. Documentary evidence comes that from the that ledger there is an entry. It shows 8,500 was withdrawn, and in support of that, a deposit slip, withdrawal slip is there.
Yes.
But unless the prosecution establishes that it is the accused, either he himself or with the aid of somebody, has prepared that forced withdrawal slip and manipulated or made false entry in the ledger, how you will establish the charge against this petitioner?
In my lord's judgment on CRLN 695 by 16, my lord has elaborately discussed about how the offense should be established.
But Mr. The other, where is the other counsel? Was there? The is it the evidence, Mr. Naik, that who was keeping that ledger with him? Usually, it is the either the postmaster in main post office, or who was keeping that ledger where this false entry has been made, that from his account this withdrawal has been made. ସେ ଯୋଉ ଲେଜରଟା କହୁନାହାନ୍ତି ଏକ୍ସିବିଟ୍ 36 ନା କେତେ, ଯୋଉଟା କି ରିଫ୍ଲେକ୍ଟ କରୁଛି 8,500 ଟଙ୍କାଟା, ମୁଁ ଏଇ ଫୋକସ୍ କରୁଛି ଗୋଟେ ୱିଟନେସ୍ ପାଇଁ। ସେମ୍ ଏଭିଡେନ୍ସ ଇଜ ଅଲମୋଷ୍ଟ ଇନ୍ 2, 3, 4। ତେଣୁ 1 ନମ୍ବର କେସ୍ରେ PW1 କେସ୍ରେ ମଧ୍ୟ 8,500 ଟଙ୍କା ଲେଜରରୁ ହେଇଛି। ସେ ଲେଜର ଚାର୍ଜରେ କିଏ ଥିଲା, ସେ ଏଭିଡେନ୍ସ ଅଛି ଆପଣଙ୍କର? କାରଣ ଗୋଟେ ପୋଷ୍ଟ ଅଫିସରେ ବିଭିନ୍ନ ଲୋକଙ୍କୁ ବିଭିନ୍ନ ରୋଲ ଦିଆହେଇଛି। କିଏ ଡାକ ବାଣ୍ଟିବ, କିଏ କାଉଣ୍ଟର ବସି ଟିକେଟ ବିକିବ, ତ ବିଭିନ୍ନ ତ ଏଇ ଯୋଉ ଜିନିଷଟା ହେଇଛି ଲେଜର ଏଣ୍ଟ୍ରି ବା ୱିଡ୍ରାଲ ସ୍ଲିପ୍ ବେସିସରେ, ଆକୁ ଜଣକୁ ଫିକ୍ସ ଅପ୍ କରିବାକୁ ହେଲେ ଲାଇବିଲିଟି ଆପଣଙ୍କୁ ଦେଖିବାକୁ ପଡିବ ନା।
Lordship, I request if the PW8 statement can be read from the beginning. More padile, it will be all clear. It is a very crucial.
No, please, there is no problem. We can read. There is time also.
Madam, that is the most.
Yes, para 4 has been described. But
No, he wants to, you place it from the beginning.
yes, ma'am.
PW8.
PW8 Satyavrat Satpathy. I was working as Assistant Superintendent of Post Office, Cuttack North Division.
Please adjust the mic to Pakunian. No.
I was working as Assistant Superintendent of Post Office, Cuttack North Division, Cuttack from February 91 to May 95. Jaspur Road Railway Station Sub Post Office was under my administration jurisdiction. At that time, Achyutananda Panda was working as supervisor of Saving Bank branch of Jaspur Road Sub Post Office. I know Hrudanand Sethi and Achyutananda Panda and Sri K.C. Mahati. At that time, they were working as postal assistant of Jaspur Road RS of Post Office, head clerk supervisor of SB branch, Jaspur Road Sub Post Office, and authorized saving bank agent of Jaspur Road Sub Post Office, respectively. As directed by the Superintendent of Post Office, Cuttack North Division, Cuttack, I conducted an inquiry into the allegation made by some depositors of the Saving Bank and RD accounts at Jaspur Road Sub Post Office. Para 4. As codified in the Postal Manual, the procedure for withdrawal from SB and RD accounts is that the depositors should submit the application form for withdrawal along with the passbook at post office counter. The concerned saving bank postal assistant should scrutinize the application form, examine and specimen signature of the depositors in the application form and compare the same with the signature in the specimen signature book, and on satisfactory certification of the specimen signature, he will allow the withdrawal. In fact, he should make necessary entry in the application for withdrawal and also make necessary entry in the concerned SB or RD passbook, authenticate the entry by putting his initial and date stamp of the concerned office, and return the passbook to the depositor with the required amount of withdrawal. Thereafter, he will prepare a list of transactions made by him during the entire day and submit all the applications for withdrawals and pay slips to the head post office along with the daily account and list of transactions. The postal assistant should also make the amount of withdrawal in the sub post office long book and sub post office ledger to confirm the entry of the amount of withdrawal in the appropriate records. In this way, a withdrawal is allowed. In some cases, withdrawal is allowed in respect of saving bank account and RD account through messenger, but messenger service is not allowed in respect of final withdrawal form. The RD account, the procedure is that the depositor should attest the signature of the messenger in the application side of the application for withdrawal. The postal assistant who deals with the withdrawal should verify the specimen signature of the depositors in the application for withdrawal, and if he is satisfied with the genuineness of the messenger, he may allow withdrawal to the messenger. When an unknown person comes to the post office being deputed as a messenger by the depositors, the genuineness of the messenger should be verified by the postal assistant before allowing withdrawal. In my presence, seizure lists were prepared by the CBI peoples, and Exhibit 25 to 28 are the said seizure list, and Exhibit 25(1) and 28(1) are my signatures. So also the specimen signatures of Hrudanand Sethi were obtained in my presence by the CBI inspector. 5 sheets by Exhibit 29 to 29A and Exhibit 29(5) to 29(9) are my signatures. Sorry. On 14/6/93, Sri Gangadhar Naik, depositors of RD account number 11508, had not submitted any withdrawal form to the post office for taking loan from his RB account. Exhibit 30 is the withdrawal form used for the purpose of same withdrawal by a person other than Sri Gangadhar Naik, the depositor, and this payment was allowed by Hrudanand Sethi and Sri Achyut Panda both the accused who had put their signature on Exhibit 13 and I am acquainted with their handwriting and signatures.
Okay, just 80 टिके रहेगा. So this is most important.
Yes.
Exhibit 30 is the withdrawal form used for the purpose of same withdrawal, means from the account of PW4, okay, which was allowed by this both the petitioners, and they had put their signatures
Yes.
on Exhibit 30, and Exhibit 30/1 and 30/2 are their signatures. Let us
This
come to Exhibit 30.
last one.
Exhibit 30, yes, sir. Exhibit 31. Chalo. Okay. 40. Sorry. 35. Out yard uncha. Madugam. So 30 adhere 5000 ଟଙ୍କା withdraw ହେଇଛି. Signature ଅଛି ଗଙ୍ଗାଧର ନାୟକର. Then 30/1 ଗୋଟେ short signature ଟେ ଏମିତି ଗୋଟେ କଣ ଅଛି. ଏବଂ ସେମିତି 30/2 ଆଉ ଗୋଟେ signature ଅଛି.
Are their signatures like?
ହଁ, ସେ କହୁଛି ଯେ ଏଇଟା 30/1 ଟା ହଉଛି ହୃଦାନନ୍ଦ ର ଆଉ 30/2 ଟା ହଉଛି ଅଚ୍ୟୁତାନନ୍ଦର. ଓକେ. Okay, let us see. Continue.
But this form has not been filled up by the appellant.
Hmm?
This withdrawal form has not been filled up by the appellant.
No, may not be filled up by your friend. You have passed it. If it
Yes,
is,
yeah, I
if
have
that you have passed it, then you are responsible. You might have utilized this somebody else service to fill up the form, but unless you pass it, it cannot be withdrawn from the account. For withdrawal of this amount from the account, your passing of this would be necessary. Passing of this withdrawal slip.
Yes.
So that they are, according to this witness PW8, 2 signatures are appearing apart from Gangadhar Naik's forged signature. Let us say this signature is one of is you and the other is of this. Okay, now you continue.
I'll take 30 seconds. Your lordships had a query on the last date of hearing. Suppose, for example, your lordships, they have not forged the signature of Arjun Shetty or not forged the signature of Gangadhar. But if forged document and their signature is there, they're also a part of a forged. They have signed it. Your lordships had quoted one Supreme Court judgment.
Yeah.
Lordships was of the view that in any of the form, if there is some signature, you find out. That query is made.
No, this witness says that 30/1 and 30/2 are their signature. He prior to that he says that let us say allowed by so and so, and both the accused persons had put their signatures. Okay, continue. Paragraph 9.
I had examined the real depositors Gangadhar Naik with reference to the said withdrawal and recorded his statement via Exhibit 21, wherein Exhibit 21/3 is my signature, and Gangadhar Naik also signed in my presence via Exhibit 21/1. I have recorded the statement in question answer form. I have obtained the signature of Gangadhar Naik at the backside of Exhibit 30, which is Exhibit 30/3. He said withdrawal has been reflected in the ledger of Gangadhar Naik marked as Exhibit 31, wherein the reflection is marked as Exhibit 31/1. Similarly, one Ramakanta Sahu.
Just a minute. The ledger of Gangadhar is marked as Exhibit 31, right? Let us see 31. 31 টা করো। এটা দেবে 30 তো এটা হচ্ছে 32 31 করো। All right, continue.
10. Similarly, one Ramakanta Sahu opened a passbook bearing account number 11569 at Jaspur Road, RS Post Office, and Exhibit 11 is his application for opening the new accounts, and Exhibit 12 is the specimen signature of Ramakant Sahu taken at the time of opening of new passbook. Exhibit 13 is the passbook of Ramakant Sahu. On 11. On 26/6/93, there was a withdrawal of rupees 2,500 from RD account number 11569, but the depositor Ramakant Sahu denied during my inquiry to have taken back the said amount, and also denied to have put his signature in the withdrawal form. Exhibit 15. The withdrawal was made by both the accused Rudanand Sethi and Achyuta Ananda Panda, and their signatures in the withdrawal form are Exhibit 15/3 and 15/4.
Again, same similar type of evidence. So, yes,
Lordship.
next. Yes, Mr. Nayak.
Lordship, similar kind of evidence. Yes, Lordship.
Similar type of. Okay, this signature, in the withdrawal form of each of these PW1, PW2, then paragraph 12, which Ramakanta means PW3. Whether he has stated about the signature of these two persons.
And in PW2.
No. PW3 रो paragraph number 12 रे पढ़ले देखिले. Paragraph 12 टा पढ़ंतु. At the time of inquiry.
At the time of inquiry, I also obtained the signature of Ramakant Sahu in Exhibit 15 and his signature therein in Exhibit 15/5. I have recorded the statement of Ramakant Sahu marked as Exhibit 16 in the questionnaire form, and my signature in Exhibit 16/3. And during my inquiry, and as per the statement, he denied to have taken that amount of rupees 2,500, and also denied to have put his signature in the withdrawal form marked as Exhibit 15.
Okay, then you come to the next one, paragraph 13. Janaki is PW2.
Yes. Similarly, one Janaki Vallabh Pradhan has opened one RD passbook, account number 11663 at Jaspur Road, Post Office, on 3/7/93. On amount of 6,000 was withdrawn from RD account number so and so, but the depositor Janaki Vallabh Pradhan during my inquiry denied to have taken payment of.
Same thing, paragraph 14, the last two lines dekhantu.
Yes.
The amount of rupees 6,000 was passed by both the accused, Rudananda Sethi and Achyutananda Panda, whose signatures are marked as Exhibit 8/2 na kona 8/3.
Yes, but in his evidence, my lord, that Janaki Vallabh Pradhan bearing RD account number 11663 stated, my passbook in respect of the above RD account always remain with Murali Babu, our office cashier. I did not complain against the accused person before any authority.
ନାଇଁ ସେମାନେ ଗୋଟେ ଲୋକ ପାସବୁକ୍ ଆଣିକିନି ଦବ, ସେଇଟା ତ ନର୍ମାଲ ପ୍ରୋସିଡିଓର. ସିଏ ପାସବୁକ୍ ଦେଇନି, ତାକୁ ଜଣା ନାହିଁ, କିନ୍ତୁ ତା ଆକାଉଣ୍ଟରୁ 8,500 ଟଙ୍କା ପଳେଇଛି, 6,000 ଟଙ୍କା ପଳେଇଛି. ଗୋଟେ ମାନେ ଇଏଟାକୁ ୟୁଟିଲାଇଜ କରିକିନି ମାନେ.
But he has not complained. But this Janaki
କମ୍ପ୍ଲେନ
Vallabh has not
ସେ ସିନା
complained.
ଜାଣିଲେ କମ୍ପ୍ଲେନ କରିବ, କେମିତି ଜାଣିବ?
In his evidence he stated that.
A complaint not call the culpability of the commission.
It's all right. Question is that whether somebody has not complained, it's all right. But when it came to fore, he gave the evidence that ମୁଁ କେବେ 6,000 ଟଙ୍କା ମୋ ଆକାଉଣ୍ଟରୁ ୱିଡ୍ର କରିନି। ଏଇ ଯୋଉ डिपोजिट स्लिप रे जो सॉरी विड्रॉल स्लिप रे जो दस्तखत अछि एटा मोर नुहे आउ ए जो तापरे इन एडिशन टू दैट PW8 रो एविडेंस जे ए जो विड्रॉल स्लिप रे जो दस्तखत अछि एटा होछि ए दी जण अक्यूज्ड कर अर्थात दी जण पिटिशनर्स तेणु एटा ए एविडेंस टा आसुची क्लिंचिंग आपनकर PW8 एविडेंस उपरे तारो ता छडा से तांकु पचारिछि से मना करछन्ती एटा आसुची। Okay, then come to this paragraph 16.
Similarly, one Arjun Shetty had opened an saving bank account number 132441 at Jaspur Road Post Office. SB 28 receipt by Exhibit 1 was granted to the depositor when the passbook concern was received from the depositor. Exhibit 3 is the specimen signature of Sri Arjun Shetty taken at the time of opening of the passbook on 2010-93. An amount of rupees 8,500 has been withdrawn from the said SB account number 132441 standing in the name of Arjun Shetty, and Exhibit 5 is the said withdrawal form. One inquiry is revealed that the amount of rupees 8,500 has not been taken payment by the depositor. It is also seen from Exhibit 5 that one Sri Arjun Chandra Shetty has applied for the withdrawal citing one Sri Pramod Kumar Shetty as messenger, and Sri Pramod Kumar Shetty has put his signature in the withdrawal form. The withdrawal was passed by both the accused Udanand Shetty
This
and
is another
Arjun Shetty.
ऐसे type bro man evidence je this is your signature on the withdrawal slip. So evidence has come through PW8 that in each of the withdrawal slip in case of 1, 2, 3 and 4
we have passed that. We
No,
have
no,
passed
passed.
the
You
we
have
have passed
passed.
withdrawal
Right,
slip.
you have passed the withdrawal. Now you continue it. Paragraph number 18.
At the time of inquiry, I have obtained the signature on the reverse of Exhibit 5, which is marked as Exhibit 5/3. I have examined Sri Arjun Shetty with reference to Exhibit 35 and taken his statement by Exhibit 6, the question answer form. This is my signature therein, marked as Exhibit 6/3, and this is the signature of Arjun Shetty, marked as Exhibit 6/4. During my examination, Shetty denied to have applied for the withdrawal and also denied to have put his signature in Exhibit 6. Exhibit 6. This is the ledger card in respect of SB account number 134441 standing in the name of Arjun Shetty, which is marked as Exhibit 34. The withdrawal of rupees 8,500 on 2010-93 has been incorporated in the said ledger card by Exhibit 34/1. Para 19. Our post office also maintains daily list of transactions of withdrawals and the deposits and submit the same to the head of post office. Exhibit 35 is the list of transactions dated 14/6/93. Exhibit 36, 37, 30, 39 and 40 are the list of transactions dated 23/12/93, 26/6/93, 3/7/93 and 20/10/93 respectively. Para 20. There is no transactions in the passbook of account passbook account number 11569 marked as Exhibit 13 on 17/1/94. This is the pay-in slip in respect of deposits of rupees 2762.50 paisa in RD passbook number account number 11569 towards repayment of loan shown to have been entered in the passbook on 26/6/93. In fact, this loan amount of 2,500 was taken payment by the accused on 26/6/93 without the knowledge of the depositor, introducing an application for withdrawal of 2,500 containing fake signature of the depositors in the said application for withdrawals. As such, the accused has also repaid the loan with interest amounting to rupees 2,762 without the knowledge of the depositors. This is the said pay-in slip marked as Exhibit 41. I have examined the depositors with reference to the Exhibit 41 and recorded his statement on 17/1/94, who has put his signature on the reverse of Exhibit 41. 41/1 is the shared signature. There's
Okay, just take pause for a moment. Let us go to the cross-examination.
Yes.
We'll read that, but let us come at this stage, come to paragraph number 31.
Yes. I was not acquainted with the handwriting and signatures of Arjun Shetty and S.K.SAHOO and J.B. Pradhan, who were account holder before the investigations.
Read it.
Para 32. I could not ascertain who had signed in the withdrawal form in the name of account holder. I have not ascertained whether those handwritings and signatures in withdrawal form belong to the accused persons or not. After inquiry, I came to the conclusion that the withdrawals were fraudulent ones. I have mentioned in my report, Exhibit 53, that H.N. Shetty, A.N. Panda, and K.C. Mohanty committed fraud in respect of withdrawal of money. I have mentioned in my report at page 5 in para 2 that the previous conduct of A.N. Panda to scrutinize the genuineness of the signature of the depositors on the withdrawal form with the specimen signatures. My report Exhibit 53 reveals examination of Suryamani Mohanty and L.D. Kar, but their statements are not available in the case record or my report. 33. I have noted in my report that my predecessor K.C. Hota had inspected Jaspur Road sub post office. I have also noted in my report that my predecessors K.C. Hota and had not reported anything adverse against the H.N. Shetty and A.N. Panda. Exhibit 53 has not been submitted by me but submitted by A.N. Sahu, the then Superintendent of Post Office, Cuttack North Division. The report which I submitted after conducting inquiry is not available in the case records. I have submitted my reports to the Superintendent of Post Office North Division, Cuttack, and basing on my report, the then Superintendent Post Office North Division, Cuttack, submitted a report to PMG Bhubaneswar via Exhibit 53. It is not a fact that I have not conducted any inquiry, submitted any report.
Continue.
It is not a fact that I have not reflected in my inquiry report that the accused person did not commit any fraud regarding withdrawal of money from passbook of account holders. It is not a fact that due to the pressure of work, accused H.N. Shetty could not verify the genuineness of the signature of the depositors in the withdrawal form with their specimen signatures, and that I advised him to deposit the shared amounts for that purpose. It is not a fact that Exhibit 54 was prepared as per directions and instructions. As per my directions and instruction, it is not a fact that no witness have signed in Exhibit 54 and I have manipulated the signatures of the witnesses therein. It is not a fact that the accused persons are no way involved in the case.
So, just take into account the witness, the most crucial part of the evidence which has given against you is that in the 4 deposit slip which has been utilized for withdrawal of money from the account of these 4 depositors or 1, 2, 3 and 4, that was passed by both of you. That is the evidence in each of the paragraph. And he stated that this is the signature of Mr. X and this is the signature of the other petitioner. You have not disputed the same.
Yes.
You have not given any suggestion that this was not passed by the accused persons. This is not the signature of these accused persons. Just think over it. ସିଏ କହିଲା ଯେ ଏଇ ଯୋଉ ୱିଡ୍ରଆଲ ସ୍ଲିପ୍ ଟାକୁ ପାସ୍ କରିଛନ୍ତି ଏଇ 2ଟା ପିଟିସନର ଏବଂ ଇଏ ହଉଛି ତାର ସିଗ୍ନେଚର, ଇଏ ହଉଛି ଆର ସିଗ୍ନେଚର। ଆପଣ ତାକୁ ସଜେସନ ଦେଲେନି ଯେ ବାବୁ ତମେ ଯୋଉ ସିଗ୍ନେଚର କହୁଛ ୱିଡ୍ରଆଲ ସ୍ଲିପ୍ ଏମାନେ ପାସ୍ କରିଥିଲେ ଏଇଟା ମିଛ, ଆଉ ଏଇ ଯୋଉ ସିଗ୍ନେଚରଟା କହୁଛ ଆର ଏଇଟା ମିଛ, ଏଇଟାର ମିଛ। ଏଇ ଯଦି ଆପଣ ଏଇଟା ନ କଲେ ଏବଂ ସେମିତି କିଛି ଏଭିଡେନ୍ସ ନ ଆଇଲେ, ସୋ ଦ୍ୟାଟ୍ ରିମେନ୍ସ ଅଲମୋଷ୍ଟ ଅନଚ୍ୟାଲେଞ୍ଜଡ। ଯଦି ଅନଚ୍ୟାଲେଞ୍ଜ ରହିଲା ତାହେଲେ ଗୋଟେ ଯୋଉ ଡିପୋଜିଟ୍ ସ୍ଲିପ୍ କୁ ୟୁଟିଲାଇଜ କରିକିନି 4ଟା ଡିପୋଜିଟ୍ ସ୍ଲିପ୍ କୁ 4ଟା ଆକାଉଣ୍ଟରୁ ଟଙ୍କା ୱିଡ୍ର ହେଇଛି, ଆପଣ as postal authority you are the persons who passed it. They were not aware because in some cases passbook has also not been there. Passbook is with the depositor, but from their account this has been done. So now in such type of cases, whether your responsibility, liability can be said that if the prosecution has proved or not. जदि आपण डिस्प्यूट करथांते जे ना ये सिग्नेचर मोर नुहे ये डिपोजिट स्लिप जो पास करची तमे कहूछ एटा मु पास करिनी से अक्यूज्ड माने पास करनांती एटा मिछ कथा कहउछनी अगेन वेरीफाई यू मे गेट समथिंग मु जो लाइटली कहूची बोथ ऑफ यू वेरीफाई दे चारिटा जाक अकाउंट जो विड्रॉल स्लिप रे से स्पेसिफिक एविडेंस दउची PW8 that these deposit slip, 4 withdrawal deposit slips have been passed, withdrawal slip has been passed by these two accused. Now I find at least that no suggestion has been given that they have not passed the withdrawal slip, and this is not the signature of any of the petitioners. तो सेटा जदि नाही ताले तार इफेक्ट कोन हबो? We'll take up this matter next week. It is be part heard. It will come.
Also, next week I have a difficulty.
No, Mr. Naik, you see, ये जो ये टा डिसकंटिन्यू हे गला असुविधा होची माने एडा को ये केस तो ऑर्डिनरी केस नो ना एडा सब डॉक्यूमेंट बेस्ड केस तेनु
not in town on that day.
Then it will come on 27th because every Thursday it is being taken out. All right, during course of argument, Mr. Madhumita Panda placed criminal division number. What is your criminal number?
21, my lord. 21 of 2000.
21 of 2003. And place the evidence of different witnesses. Mr. Sarthak Naik, Lanen, Special Public Prosecutor for CBI, also present. Hard in part, the matter be listed on 27th of July, 2023. That would be easier. While placing the evidence of PW8 by Mrs. Panda, it is noticed that the said witness who was working as Assistant Superintendent of Post Office, Cuttack North Division, Cuttack, stated that he knew the petitioner, Hrudanand Sethi, who was working as Postal Assistant of Jajpur Road Sub Post Office, and petitioner Achyutananda Panda was working as head clerk, bracket supervisor of SB branch Jajpur Road. Sub Post Office. And in paragraph number, से जो paragraph रे जो signature ओडा को paragraph रे अछि? हाँ, in paragraph number 8, comma,
Eight 11.
11, 14, and 17. He has stated that the withdrawal slip was passed by both the petitioners.
And not passed, my lord. I am a supervisor, my lord. Government circular ଅଛି postal circular. ମୁଁ ଖାଲି supervisor କରିବି, ମୋର responsibility liability ନାହିଁ.
Evidence ଟା ଦେଖି କଥାବାର୍ତ୍ତା କରନ୍ତୁ.
My lord.
Evidence ଲେଖା ହେଇଛି।
Was passed by both the petitioners, and he has also proved the signatures of both the petitioners on the respective withdrawal slips. During cross-examination, it appears that no suggestion has been given to PW8 that withdrawal slips, the statement that his statement that withdrawal was passed by both the petitioner is not correct, and that the signatures of both the petitioners on the withdrawal slip to be that of the petitioners is not correct. Thus, this part of evidence of PW8 seems to be remain unchallenged. The learned counsel for both the parties submitted that they will further examine the evidence of PW8 minutely, so also the other available evidence on record as to whether this part of evidence of PW8 has been shaken in any manner or not. এটা ରଖିଥାଅ ହେଲା, this should be helpful for me. You just kept it in mind. ଆଉ ଥରେ minutely ପଢି ପଢିକିନି ଯିବେ। ପ୍ରତ୍ୟେକ ସେ ଯୋଉ last 3-4ଟା ଲାଇନ ଯୋଉ କହୁଛନ୍ତି ଯେ withdrawal was passed by both the accused Rudananda Sethi and Achyutananda Panda, and exhibit this and this are the signatures of so and so. ଉପରେ କହିଛି ଯେ ମୁଁ ଜାଣିଛି ତାଙ୍କୁ ସିଏ ଇଏ କରୁଥିଲେ, ସେ ତେଣୁ ତାକୁ ଡିମୋଲିଶ କରିବା ପାଇଁ କଣ ଆସିଛି ଏଭିଡେନ୍ସ, କାରଣ ଏଠି ପାସବୁକ୍ ପ୍ରଡ୍ୟୁସ ହେଇନି ମାନେ 3ଟା କେସରେ, ମେ ବି ଯୋଉ 2, 3, 4 1 ନମ୍ବର କେସରେ ପ୍ରାଇସ୍ ପ୍ରଡ୍ୟୁସ ହେଇଛି, ବଟ୍ ଦ୍ୟାଟ୍ ଇଜ ଫର ସମ୍ ଅଦର ପର୍ପସ୍। ସେ କହିଲେ ଯେ ମୁଁ ପଠେଇଦେବି, ତେଣୁ ଇନସ୍ପାଇଟ୍ ଅଫ୍ ଯୋଉ ପ୍ରୋସିଡିଓର ସେ ଫଲୋ କହିଲା, ନାଇଁ ଆଉ ଗୋଟେ ଲେଖିଦ in addition upper lekhiyo PW8 in addition to that stated that how withdrawal can be made from the a postal account either by
Paragraph-
the
in paragraph 4.
By the person concerned or by sending a messenger. In paragraph number 4 paragraph रे कहला 4 and 5 बोधे 4 and 5 कर दियो है ना सेटा ऊपर रख दियो रेफरेंस में
ଆଉ ଗୋଟେ ଜଜମେଣ୍ଟ ଆପଣ କହିଥିଲେ ଦେଖିବାକୁ lordships
हम्म
on the last date of hearing.
हाँ नहीं ଏଇଟା
ଆପଣ କହିଥିଲେ ଗୋଟେ ଜଜମେଣ୍ଟ ଦେଖିବାକୁ ଯେ ଯଦି suppose your lordship they have not forced the signature of the depositors, but if the entire basis of the document is forged document, any part signature is also a forgery.
no, that is the definition. In that
Yes.
definition, a part of it, not necessarily that the entire thing has to be somebody else has done it, but they have endorsed it. So they are party to it. Suppose it is not coming that actually whose signature is there on that deposit slip. Mane say jo withdrawal ପାଇଁ କିଏ So PW 1, 2, 3 and 4 ର signature ଗୁଡାକ ଯଦି ସେମାନେ deny କରୁଛନ୍ତି ଆଚ୍ଛା have you given any suggestion to this 1, 2, 3 and 4 that ଏଇ ଯୋଉ deposit slip ରେ ଆପଣ କହୁଛନ୍ତି ଏଇଟା ଆପଣଙ୍କର signature ନୁହେଁ ଏଇଟା ମିଛ କଥା ଆପଣ ହିଁ withdrawal slip ଦେଇକିନି ଟଙ୍କା ନେଇଥିଲେ ଏମିତି କିଛି ଦେଇଛନ୍ତି ସଜେସନ 1, 2, 3, 4 କାରଣ 1 ଟା କହିଲାନି କି ଗୋଟେ 1 କହିଲା ଯେ ଏଗୁଡା it is not my signature ସେ କହିଲା I have never withdrawn 8,500 paragraph 2 and the signature in the withdrawal slip marked as so and so is not my signature. Withdrawal slip is marked as exhibit 5 ହେଲା so whether any suggestion has been given to him that ନାଇଁ ତମେ ଅମକ ତାରିଖ ଦିନ ଆସିଥିଲ ବ୍ୟାଙ୍କକୁ ତମେ ଏଇଟାକୁ ପୂରଣ କରି ଦେଇଛ ଏବଂ withdraw କରିଛ ଏମିତି କିଛି suggestion ଦିଆ ହେଇଛି yes perhaps that has been given. It's not a fact that by submitting withdrawal slip I have received 8,500 out of SB account through my messenger. So that is your case, Pramod Kumar Sethi. It's not a fact that though I have received 8,500 out of this so and so, I have falsely lost the complaint. That is the okay. What about 2?
And two says that my passbook in respect of the above RD account is always remain with Murali Babu, our office cashier. I did not complain against the two accused persons before any authority. I have received the matured amount after 8 months of the matured dates. Besides examination by the postal authorities and the recording my statement, the CBI inspector had examined me, but I do not remember the date. But it
ନାଇଁ ମୁଁ ସେ କଥା କହୁନି ଆପଣ ସେ ଯୋଉ ଚିଫ୍ ରେ ଯୋଉ ଲାଇନ୍ ଟା କହିଲା I never withdrew rupees 6,000 ଟଙ୍କା from my aforesaid RD account. The signature marked as so and so in the withdrawal slip are not my signature. Withdrawal slip ଟା 8,000 exhibit 8 mark ହେଲା ଆପଣ ଏ witness କୁ suggestion ଦେଲେ କି ଯେ ନାଇଁ ବାବୁ ତମେ ହିଁ withdraw କରିଛ 6,000 ଟଙ୍କାରୁ ଆଉ ଏଇ ଯୋଉ signature ଆସିଛି ଏଇଟା ତମରି signature.
Basically, what line it is not a fact that mark Y and Y1 are my signature.
Or my signature. ସେତିକି ଗୋଟେ ଲାଇନ୍ ଖାଲି କରାହେଇଛି 6,000 ଟଙ୍କାଟା କିଛି dispute ହେଇନି. Okay, next.
I have not lost anything.
ନାଇଁ complain କରୁ କି ନ କରୁ ସେତେବେଳେ let us see next PW3 ତା account ରୁ କେତେ ଟଙ୍କା withdraw ହେଇଛି 2,500 ସେଇ ଟାଇପର evidence ଥିଲା On 26/1, so I withdrew rupees 1 so from the said account. After the maturity of the said cashier authorized me to get the passbook from the postal department. This is the authorization. The rest.
It is not a fact that to have the accused I am suppressing the
Oh, I see. ये hostile लेगा था मैंने PW3 hostile वाला. Okay, then PW4.
PW4 the deposits in my accounts are used to be made through my office only. I never withdraw any amount.
On 14/6/1, so I have not withdrawn rupees 5,000 from the said account. This is not the withdrawal slip submitted by me. So I have lost rupees 5,000 from the above account for which, okay. Then
I have withdrawn the amount against my. It is not a fact that my answer in Exhibit 21 are false. I have withdrawn the amount against my aforesaid account which I am entitled to. Initially, I have lost 5,000. Thereafter, it was compensated.
କାରଣ ଗୋଟିଏ ସାକ୍ଷୀ 4 ଜଣ ଡିପୋଜିଟର ଭିତରୁ ଗୋଟିଏ ସାକ୍ଷୀ ସପୋର୍ଟ କରିନି ବଟ୍ ଅନ୍ୟ ସାକ୍ଷୀ ଗୁଡାକ କହୁଛନ୍ତି ସେ ବିଷୟରେ।
ଆଉ ଗୋଟେ କଥା your lordships
yes,
very crucial aspect your lordships exhibit 51 and 52 are the statement of both the accused. These statements were made before the accused before PW8 while he was the inquiry officer. If your lordship peruse that exhibit 51 and 52, there they have stated that the handwriting of are not tallying. Is that the handwriting in the deposit slip and the current handwriting, these are different. So they themselves have before PW8 in that inquiry, your lordship. That is exhibit 51 and 52.
All right. We'll take up this matter on
my
27.
lord, my respectful assumption, my lord. Paper book already ready. I have not all document. Office may be directed to supply a paper book, my lord.
Paper book तो prepare ही नहीं?
He is, my lord, already ready.
Paper book, हाँ paper book. अच्छा हाँ paper book prepare. एक तो paper book तो दे दियो उठा, है ना? Take it.
My lord.
Your lordship said weekly list items 6 and 7 were supposed to be taken up today, your lordships.
Yes.
The next difficulty both are CBI matters. Those two matters, your lordship, may also be taken on 27th. 3 of them.
Mr. Naik, on that day there are some other part-hard matters. This matter would have come in item number 1.
Yes, your lordship.
But there are 2 to 3 matters which have also heard today. So obviously your matter may not reach on 20th.
And by chance, if some lordship,
just ask someone to just mention on that day in case it reaches. Ask one of your associate in case it reaches. I say because I used to deliver the judgment in open court. So tell on that day. Okay.
Please, your lordship.
Paper book has not been prepared. Who told you that paper book has been prepared?
My lord, कहले तो paper book
Paper book has not been prepared. If you want to take the evidence copy, etc., ask your friend. She will supply you.
Always, my lord.